5 kilometers. And it was supposed to be started from the Yorte, Tabiar PMGS route to Yangte PMGS route, connecting the two PMGS route. But they have constructed only from Yorte. Yorte is a point 3 kilometers away from the Tabiar, the starting point. And when the people requested, and they are not reluctant to construct that portion, Tabiar to Yarte portion. And detail of this project was like the formation cutting 5.22 kilometer, and Kachar drain 5.16 kilometer, culvert 14 numbers, and Belly Bridge 1 number. Then the GSP 5.163 and WBM 3.5, totaling around 5.22, of which only respondent has constructed only 2 kilometers. And that way they want to gobble up the public money. And as when I saw the document from the respondent through RTI Act, they have denied, and they showed me one letter which you honor your lordship may peruse in page number 199A. Here, let me read. To the executive engineer, this is a response number 5, and who is writing the BM interpreter, response number 6. To the executive engineer, public work department, Jamming division, Palin, subject and intimation letter regarding the disclosure of any related document to any RTA activist. Respected sir.
Who are you? Who are you?
I am social activist of local area.
What do you do?
I am just social worker.
What do you do for a living?
Pardon?
What do you do for a living? What is your means of livelihood?
Livelihood, I'm a contractor.
Huh?
Contractor.
You're a contractor?
Yes.
So you're also interested in the job?
Yes.
And you did not get the job?
No.
And therefore you have come up with this litigation?
No, I want that the rules should be properly constructed.
No, but who are you? Why should we examine this at your instance?
No, because it affects me. I'm one of the land affected people.
No, you have also named a particular association. That association is not before us. What is the name of the association? Tabiar to Yangte PWD Road Construction Victimized Families Association. Is it a registered association?
It is not registered association, but local association.
This association is not before us.
On behalf of
where are your statements in accordance with the High Court rules that you you undertake to pay the cost?
But
the High Court rule says that you have to make a statement on affidavit that if in case this is dismissed, you have to, and costs are imposed, you are in a position to pay the cost.
We have given a pleader notice.
No, where is your statement? Try to understand the question. Have you seen the High Court rules? Have you consulted the High Court rules pertaining to PIL?
Pardon?
Have you consulted the High Court rules pertaining to filing of PILs?
Yes.
Where is the statement with regard to cost? High Court rules.
It is. It is 226 of the Constitution of India.
You have not understood. You have not understood. You have not read the High Court rules. Where are the High Court rules? Okay, we are giving you the copy.
Now I'm filing this under 226.
This is a PIL.
Yes.
Is there any doubt that it is a PIL?
Yeah.
If you file a PIL, there are a set of rules which you have to follow.
I mentioned in a specific.
Where?
And
Which paragraph?
Paragraph?
No, I'm asking which
Yes.
paragraph is that.
para 5, last sentence, that the petitioner undertake to pay fine if any imposed by the honorable court in respect of.
Where? Paragraph?
With paragraph 5,
Page 13, Malak.
page 13, yeah,
Last para.
yeah. That the petitioner undertakes to pay fine if any imposed by this honorable court in respect of withdrawal, etc. of this instant by PIL. And here, yeah,
Have you seen the part 3? Have a look at this. Anyone of you have the High Court rules?
Anybody?
Have you said, do you have a copy of the High Court rules?
देख
Have a look at this. You have not followed the prescription of the rules. These rules are made only to avoid any litigation which is not filed bona fide. What is to be given in the first paragraph, second paragraph, everything has been given. Mr. Nabam, you just have a look and try to explain it to him. 488 page.
here is the question of the fine.
Not only fine, there is all other formats.
Yes,
See, there is a format.
Yeah.
What has to be there in paragraph 1 has to be there in paragraph 2. Everything is there. You have not followed the format.
it is given, sir.
You may argue that these are very technical matters, but these are not technical.
No,
These rules have been
we have-
incorporated with a very
we have given
with an
a-
objective.
we have given a pleader notice also, but they have.
Reader notice is not the requirement.
So,
Requirement is following of the format.
but it is in the public interest we are doing.
Your saying will not do. That is why the format, the rules have been framed to avoid any unnecessary litigation or any exercise of power which is not one of it.
Yeah.
Which paragraph you have listed?
Everything is there. And these are not new rules. These are framed quite some time back.
Yes.
my Lord Justice Fokan, which was passed in the interlocutory application. Thereafter, amendment came. And amendment came because of the recommendation of the board. So, my Lord, the Hayden's principle will come into play. The mischief rule. What exactly was the mischief earlier and how the mischief was sought to be rectified. But, my Lord, a degree of contradiction has come in. That is why the item number 1. And another aspect is the petitioners are different in both the cases. In item number 3, the petitioners are those very officers whose names are very much within the zone of consideration for the purpose of promotion, and their names appear in the WT message. They are among the 54 officers. Whereas, my Lord, in the item number 2, the new writ petition, their names do not appear. They do not come in the zone of consideration, and therein lies their grievance. They do not come in the zone of consideration because of the intrinsic difficulty which has given rise to this very particular case. So, my Lord, I'll just place the relevant facts. In the state of Arunachal Pradesh, my Lord, there are 3 wings of the police force. One is the civil police. We understand in common parlance what the civil police is all about. Then there is Indian Reserve Battalion. And we have got Arunachal Pradesh Armed Police Battalion. These are the 3 wings. Now, so far as, my Lord, in the 3 wings, the IRBN is concerned, subsequently I will show to your Lordship, IRBN was funded by the central government, and there was a specific clause when the IRBN was raised that those who will be appointed in the IRBN, they can be deployed anywhere in the country. And when the appointment letter was issued, it was clearly pointed out that those recruited in the IRBN will remain in the IRBN. That is a very, very important aspect, because when we talk about the integration and amalgamation of all the 3 forces, these difficulties will arise. So, my Lord, 3 different wings: civil police, IRBN, Arunachal Armed Police Battalion. Now, my Lord, in all the 3 wings, till the cadre of inspectors, the recruitment rules are different, channels are different, and, my Lord, cadres are different, till the stage of inspector. After the inspector, my Lord, the higher grade is, and there we are governed by Arunachal Pradesh Police Service Rules 1989. That cadre is called Arunachal Pradesh Police Service Entry Grade cadre, entry grade, under the 89 rules, Arunachal Pradesh Police Service Rules. Feeder cadre is inspector. From inspector, my Lord, promotion is made to the entry grade in the Arunachal Pradesh Police Service.
What is the name of the entry grade?
Arunachal Pradesh Police Service entry grade, they call it.
What is the name of the post?
Name of the post, DYSP in civil police, Deputy Superintendent of Police, and SDPO, Sub-Divisional Police Officer. In the civil police, Assistant Commandant,
Cadre is the same. It's
Service
one cadre.
entry grade, they call it. Entry grade, they call it. And, my Lord, in civil police, we have DYSP and SDPO. In IRBN, we have got Assistant Commandant. In Armed Police Battalion, we also have Assistant Commandant. Equivalent.
Okay.
Now, my Lord, the difficulties arose, my Lord, to begin with. It was in 2009 that for the first time, they prepared a consolidated seniority list of inspector of all the 3 wings. They amalgamated, because we had separate seniority list of all the 3 wings till the stage of inspector. In 2009, they amalgamated the seniority list.
Okay.
This, my Lord, will find Annexure 11 in the writ petition. I will skip it. No need to show. So, amalgamated seniority list. Page, my Lord, page 117 to 121. This was provisional seniority list dated 28th of May,
That is
2009.
amalgamated.
For the first time. The idea was, my Lord, from the amalgamated seniority list, they will make promotion. This was challenged, my Lord, for the first time in a writ petition, that is WPC 42 of 2012. And, my Lord, in this very writ petition, the rule was also challenged. Possibly the rule 50. Matter came before the division bench, and my Lord will find the order dated 13th May 2015 at page 122 of the writ petition. Page 122.
Order dated.
Order dated 13th May 2015.
Okay.
Relevant page, my lord, page 123.
Particular 2011.
Yes, my lord. 42 of 2012.
The copy 2011 at 122. Okay, it should be 12, I think.
Page 123.
At 122, it's somehow 2011 appears. At
Okay.
122.
But in the next
No,
page.
no, I understood. I think it's
Yes,
wrongly
yes,
typed.
yes. Wrongly typed, my lord, wrongly typed. The next page it is
Yes.
2012.
Yes, yes,
This is B.K. Sharma and Manojit Mohan.
yes.
Now, relevant page 123, my lord, I'll read from this quoted portion, the last para, page 123. The writ petitioners, 29 in numbers, who were working as sub-inspector and inspector respectively in Arunachal Pradesh Police, assailing the impugned integrated seniority list of inspector dated 28th May 2009 of APP Battalion and IRBN and Arunachal Pradesh Police Recruitment Rules 1989. The petitioners accept the petition number 27 were initially appointed as sub-inspector ranging from 1985 to 2004. In Arunachal Pradesh Police, there are three departments, APP, APPBN, and IRBN, having their own set of rules for appointment, including the post of sub-inspector and inspector. The APP is called Civil Police, and the rest two, APP Battalion and IRBN, are called Armed Force Police. The Armed Force Police were raised for maintaining law and order duties. In Arunachal Pradesh Police, the sub-inspector of 1985 batch are still working in same capacity without any promotion. But in IRBN, the appointee of 2004 are being given promotion to the higher post of inspector within 5 years period. Because career progression is very slow so far as civil police is concerned. For 10 years to 15 years in SI, then only we are promoted to inspector. In their case, career progression is very fast. They become inspector very quick. And for promotion to the post of DYSP stroke assistant commandant, there are set of rules which are called Arunachal Pradesh Police Recruitment Rules 1989, wherein no reservation has been prescribed for promotion of DYSP assistant commandant from inspector serving in three departments. Though there are vast variations of sanctioned strength of SI and inspector in APP Battalion and IRBN. However, authorities in most illegal manner prepared impugned integrated seniority list of inspector for such and such, whereby the private respondents, inspectors who are far junior to the petitioner, have been placed above them in the impugned integrated seniority list of inspector. Hence, this petition for rectification of recruitment rules 89 by formulating reservation of two posts of assistant commandant for Armed Police Battalion and IRBN and rest for Civil Police, and for setting aside and quashing the impugned integrated seniority list of inspector, and for preparing separate list of inspector of APP Battalion and IRBN. So this was sub and substance. Then page 125, the last two paragraphs. Page 125, last two paragraphs. Since the matter is said to be under active consideration of the government, the writ petition is disposed of, directing the respondent 1 and 2 to take appropriate decision in the matter, taking note of all the attending facts and circumstances and in accordance with law. The decision shall be conveyed by a speaking order, and the same shall be passed as early as possible, preferably within 31/8/2015. Such and such. At this stage, learned counsel for the petitioner expressed his apprehension that in the meantime, respondents may promote the persons from the integrated seniority list to the post of DSP. It is hereby provided that the promotion, if any, shall be subject to the exercise required to be carried out by the respondent in terms of this order. So court said, look into this, pass a speaking order, and whatever, that is it. So, my lord, thereafter, my lord, in terms of this very particular order, finally, they constituted the board to look into the whole matter. The board gave its recommendation dated 9th October 2015, which my lord will find at page 126. Before I point out the relevant portions of this recommendation, My lord, just one thing to be noted at page 126, civil police, they have shown the chart. The various cadres, bottom to top, methodology, serial number 5, my lord will find inspector, 100% promotion seniority, higher post is DYSP, APPS integrate. That is it. They have shown the various. Likewise, the next page, Armed Police Battalion, the next chart, page 127. Serial number 4, inspector. 100% promotion seniority. Higher post is assistant commandant in APPS integrate. The third chart, IRBN. Column serial number 5, inspector. Higher post is assistant commandant, APPS integrate. Now, my lord, some of the relevant portions of the recommendation, page 127. After the chart I am reading. The last para is straight away, my lord may see. In this context, the last paragraph of page 127. In this context, the board member had a discussion on the common seniority list at length, and it is found that as per recruitment rules of civil police, APP battalion, IRBN, the qualifying length of service for promotion from the rank of sub-inspector to inspector and inspector to APPS centigrade is 10 years. Sub-inspector to inspector 5 years and inspector to APPS centigrade 5 years. However, on close examination of the career progression of the 3 units, civil police, armed police battalion and IRBN, it is found that the career progression of officers recruited under IRBN is much faster than the civil police and armed police battalion up to the rank of inspector from constable and sub-inspector. Record reveals that presently 17 sub-inspectors directly recruited of civil police of 1987 batch, despite completion of 29 years of regular service, have not been promoted to the rank of inspector. So this is the condition. 29 years serving as sub-inspector, they could not be promoted to inspector due to slow career progression. Whereas in case of IRBN cadre, 4 very junior sub-inspector of IRBN cadre of 2004 batch are promoted to the rank of inspector and their seniority position in the combined seniority list of inspector are enlisted at 88, 89, 90 and 91 respectively. As per the recruitment rules, they have already attained the requisite qualifying length of service and become eligible for promotion to APPS centigrade. Likewise, many of the inspectors, IRBN of 2006 batch sub-inspectors are also going to be eligible for promotion to APPS centigrade by 2016. Under this circumstance, it is found that much junior sub-inspector of IRBN will be promoted to APPS centigrade by superseding much senior sub-inspector of civil police, that is senior by 18 years, possessing more experience, which will adversely affect the administration and discipline of the force. As cadre being same at top level, they shall be eventually posted above them. They have already superseded senior civil police sub-inspectors in their own batches. Naturally, because once you integrate, they become inspector very quickly. So, my lord, they become inspector. And in the integrated seniority list, they are higher. They are higher, they are in the zone of consideration. They are in the zone of consideration, they make it to APPS centigrade. Therefore, it is found that maintenance of common seniority list of inspector civil police, armed police battalion, IRBN is causing problem, raising heartburn, and this predicament is causing apprehension and competition among the sub-inspector of civil police and armed police. Consequently, sub-inspectors of civil police, the petitioner sub-inspector such and such have gone to High Court to protect their promotion prospect and sought court's intervention in the matter for separate cadre. So this is the problem, my lord. Straight away, instead of reading so various examples they gave. Finally, my lord, the recommendations are at page 130.
130.
Yes. The last after the chart. Relevant recommendations I will read. Recommendation number 2, my lord will see. Recommendation number 2, that the officers of Armed Police Battalion, IRBN cadre, promoted to the rank of assistant commandant, deputy commandant, second in commandant and commandant in their own cadre shall wear their own unit badges the recommended grade nomenclature vis-a-vis APPS is as under. Such and such. Then number 3, that officer of armed police battalion and IRBN cadre shall be posted only in respective battalion and IRBN cadre. That means they will remain in their own. However, APPS officers may be posted to take charge of commandant, second in commandant, deputy commandant, assistant commandant as per requirement and exigency of the department. So, my lord, in the case of civil police, this may be a temporary phenomena, but permanently armed police battalion and IRBN, they will remain where they are. They will get promotion in their own wing only. 4, since the officers of armed police battalion, IRBN cadre promoted against the promotion quota shall no longer be APPS cadre, they shall not be eligible to be nominated, inducted into IPS cadre in latter stages. 5, that unlike that of civil police, the training of direct recruit sub-inspectors in armed police battalion and IRBN shall be carried out in institutions similar to that of Central Armed Police Force to make them more regiment orientation required in the armed police. So, my lord, these were the recommendations of the board. Thereafter, my lord, instead of acting upon the recommendation, what they did, on 17th October 2017, a WT message was issued. WT message had contained 40 names of inspectors for the purpose of considering the cases for promotion to APPS anti-grade. And, my lord, these 40 names were from civil police, inspectors of civil police, armed police battalion and IRBN. That is, my lord, consolidated WT message, including these names together from the inspector. Naturally, my lord, these names were in terms of seniority in the inspector grade. So, they had not separated the seniority list, integrated.
The recommendations of the board were not implemented.
Not implemented. And WT message was issued. This WT message, my lord, dated 17th October 2017, it was challenged in the second writ petition. This is WPC 20 AP of 2018. In this writ petition, my lord,
20 WPC
20 AP 2018. In this writ petition, my lord, the order was passed on 29th January 2018 at page 134. Relevant portion 139. 139 is the relevant portion. (139), the last para I am reading. (139), last para. Yes, last paragraph, my lord. 2 paras I will read. The petitioner's grievance is that they have been working as inspectors in the APP Civil Police and they were initially appointed as sub-inspector way back in the year 88, 89, 90, 93 and 94 respectively. The petitioners have contended that the state government had created 32 posts of deputy superintendent of police specifically meant for civil police, while order dated such and such under memo such and such. However, pursuant to the creation of the said post, the respondent authorities had issued the WT message dated 17/10/2017, including the names of 40 inspectors for their promotion to the post of DSP under the APP Civil Police in the ensuing departmental promotion committee. According to the petitioners, the inspectors who have been appointed in the APP Civil Police and IRBN have separate channel of promotion and therefore are governed by different set of recruitment rules. Then the next paragraph. From a perusal of the said appointment order dated 5/2/2004, it can be seen that the private respondent 6 to 9 were initially appointed as sub-inspector of police in the IRBN on condition inter alia that they will be required to serve only in the IRBN and their services are not transferable to civil police and armed police battalion. However, in spite of their service being not born in the civil police, their names have been reflected in the
ultimately the representation was directed to be.
Yes. Then, my lord, thereafter, pursuant to the direction of the court, a speaking order was passed by the commissioner. The speaking order, my lord, is dated 5th November 2018, page 142. 5th November 2018 is a speaking order. The page 142, third paragraph. 142.
The speaking order,
Yes.
5th November,
Detailed order by the Commissioner.
511,
Commissioner, Home Government of Arunachal Pradesh.
511.
Yes, my lord. Yes.
Okay.
Paragraph 3, 4 and 9. 3 paragraphs I will read. Para 3. Whereas the issue raised in the aforesaid representation relates to the greater issue of cadre management and maintenance of seniority list for the 3 cadres, in respect whereof a proposal for preparation of a combined integrated seniority list of Inspector of Civil Police IRBN had been received from the police department, while their letter number such and such dated 5/10/2014. Next, whereas the aforesaid proposal of the police department for preparation of a combined integrated seniority list of inspectors had been examined in detail, and it has been found that the existing 3 cadres, namely APP Civil Police, APP Battalion and IRBN, are separate cadres and have their own set of recruitment rules for appointment to promotion from constable up to the rank of inspector. Promotion of inspectors of 3 cadres to the rank of APPS anti-grade, that is Deputy SP Assistant Commandant, is governed by a set of rules called as Arunachal Pradesh Police Service Rules 1989, 2006 amendment. Whereas a specific number of posts for promotion of inspectors of 3 cadres to the respective rank of APPS anti-grade, DYSP Assistant Commandant, 1st and 2nd Armed Police Battalion, Assistant Commandant, 1st and 2nd IRBN, has been prescribed. The recruitment rules also prescribe a specific number of seats for promotion of APPS centigrade officers to the rank of APPS grade 1, promotion of APPS grade 1 officers to the grade of APPS GAG, and promotion of APPS GAG officers to the grade of APPS special grade. Then para 9. Now, therefore, in view of the foregoing facts and circumstances, the present proposal of the police department seeking government approval to the draft provisional combined seniority list of Inspector of Civil Police IRBN APPBN is hereby rejected. In the result, the government consideration of the plea for withdrawing the names of 4 inspectors of IRBN from the draft provisional seniority list prepared by the petitioner in the aforesaid representation at this stage does not arise. However, the larger issue of cadre management and maintenance of seniority list will be resolved after taking an appropriate decision in the matter in the manner indicated in para 8 above. The para 8, my lord, is, and whereas an appropriate decision shall be taken by the government on the basis of the fresh proposal from the police department on the basis of these comparative studies, taking into consideration all aspects of the issue involved, and this decision will also entail amendment of the recruitment rules, for which approval of the service rules amending the authority state cabinet is mandatory. So, my lord, the result is the suggestion was rules may be amended. Number 2, the combined seniority list which was prepared, it was done away with. It was rejected. So no seniority list integrated pursuant to the speaking order. And suggestion was amend the recruitment rules if necessary, because separate cadres have to be maintained. This was the result. Then, my lord, ignoring all this, they are merrily following their own path. Ignoring everything, the Under Secretary Home on 8th October 2020 conveyed government approval of proposal for common cadre of Arunachal Pradesh Police with prospective effect. That is, my lord, page 176. Common cadre. Page 176, 8th October 2020. With reference to letter number such and such, I am directed to convey, page 176. I am directed to convey the government approval for common cadre of Arunachal Pradesh Police with a prospective effect. This was, my lord, challenged in the presented petition. Item number 3. That is WPC 405. And various other prayers were also made, my lord, in the presented petition, challenging this very approval of proposal for common cadre.
Okay.
Now, my lord, writ petition was filed in 2021.
This is the subject matter of.
Yes,
the-
present writ petition. So this was challenged. In the writ petition, various other reliefs were also sought for. Petition was filed in 2021. Now, my lord, during the pendency of the petition, there were few positive developments. The developments were on 13/9/23, the final seniority list of inspectors was published. And my lord, interestingly, this list was not a common seniority list. It was separate. This, my lord, this was part of the interlocutory application. Then we filed interlocutory application, bringing on record these developments.
Just a minute, please. There is an interim order here.
Interim order, my lord, came in the IA.
Oh,
IA.
no, during the pendency of this.
During the pendency, subject to the lordship
What has
happens.
happened? What-
And if anything happens,
No, what order was passed?
the order was to the effect that interim order
No,
initially.
not interim order. No, we are not on the interim. You said that during the pendency of the writ petition.
Yes, during the pendency of the writ petition, they published the seniority list, separate seniority list
Date,
of inspectors. It is 13/9/23. It is part of the interlocutory application. In IA, my lord will find at page 26.
separate seniority list.
Yes. It's interesting. I'll just show, my lord. Page 26 of the IA.
What made you file the IA?
The IA, my lord, I beg your pardon?
No, why did you, what?
Yes, IA was filed. That's why I'll just place the facts. Automatically, my lord will understand the reason why we filed the IA. So the seniority list was prepared. And
It's a
page
separate,
separate.
okay, no grievance with that.
No grievance. We were happy with that. After the seniority list, on 14/11/23, a WT message was issued, and this was a trigger for IA. 14/11/23, WT message was issued. The WT message, my lord, contained 54 names of inspectors from all the three list. And my lord, the basis of inclusion in serial order was the length of service in the cadre of inspector. Naturally, my lord, those who were junior to us as SI, they were higher up in the WT message for the purpose of promotion to APPS anti-grade. WT messages 14/11/23. This was impugned in the IA. Out of the 54 names, my lord, in the WT message, 26 names were of civil police, 20 names from the IRBN, and 8 names from the armed police battalion. All inspectors. All inspectors.
26 from civil, 20 from IRBN.
And 8 from armed police battalion. All inspectors. Now, my lord, we submitted a representation. Representation will be important for one purpose. I will just show the example. Representation is also part of the IA. It is 21/11/23 at page 39.
You filed representation.
Yes, my lord.
Okay, then you filed the IA.
Yes, my lord, but kindly, lordship may have a look. It will be relevant for some reason. I'll just show something. No, please, there is something. My lord will notice one thing here. In the representation, we have prepared a chart. Ourselves, we showed. We compared. The senior most IRBN inspector is from IRBN. He is at serial number 4 in the chart. Prior to him, there are 3 names. Of course, they are very senior in civil police inspectors. Now, I'll compare this number 4 inspector IRBN with, my lord, the last man in the chart in civil police inspector at 54. My lord will find the inspector at serial number 54 in the chart. It is also in terms of WT message, serial order. My lord, he became sub-inspector on 27th January 94 at number 54. 27th January 94, whereas at serial number 4, Inspector IRBN became sub-inspector on 26/10/2005.
Almost 10 years, more than 10 years.
but
No,
he is
no,
higher.
no, particular instance, you may not go. We have understood.
Just.
That
This is
the-
the problem. So, my lord, IA was filed.
IA number,
IA is, my lord, it is 203 of 2023.
23.
In this IA, my lord, the order of Justice Fukan is there. Lordship has seen the order. I will not refer to it. Now, my lord,
Yes, sir.
after the IA,
Yes, sir. Hmm.
after the IA,
What order was passed?
IA, my lord, the order is,
You said that some interim order was passed.
yes, it's very elaborate order. This is the interim order is annexed in the item number 2 writ petition. It is at page 142.
Order is 2112.
Yes. 20, order is 2112. Yes, my lord. WT message was the state. Paragraph 11 is an operative portion. I will just read that. In the result, at page 149. In the result, having considered the facts and circumstances on the record, as well as submission of learned counsels of both sides, and having prima facie satisfied, this court is inclined to stay the impugned WT message dated 14/11/23 till next date, on which endeavor will be made to finally hear the writ petition such and such. Now, my lord, after the WT message, sorry, after this interim order, the amendment came. 2023 amendment. And 2023 amendment is very interesting. It substantially meets our grievance, but not totally, because contradiction is coming. Possibly, my lord, somewhere they lost the focus and made the mistake. I will show this.
You are now taking us to the new writ petition.
New writ petition, my lord, straight away I am taking my lord to the rule. Why I am challenging the rule? And my lord, I'll just clarify who are the petitioners here in the new writ petition. In the new writ petition, those inspectors are the petitioners whose names did not even appear in the WT message containing 54 names. But my lord, in terms of seniority, they are senior to almost all the inspectors of IRB and Armed Police Battalion, except at serial number 4. He is senior, rest of all junior to these very petitioners. But they could not appear in the list for the simple reason, as inspector, my lord, they do not have sufficient years as length of service so as to come in the zone of consideration. But those people, they get the promotion early. They have served as inspector for many years and they have figured in the list for promotion. And my lord, another aspect is they do not clarify that it appears now from a subsequent document which I will show in the writ petition. The WT message containing 54 names was for the purpose of promotion to 19 vacancies. Now, in 19 vacancies, how many vacancies are for the assistant commandant in Armed Police Battalion, assistant commandant in the IRBN, or in the civil police? They don't say. The idea is very clear. What they want is a common cadre. And common cadre this way is not possible, because that will be injustice.
Where is the amendment?
The amendment, my lord, because since, my lord, they have not published the complete rules incorporating the amendment, so I have got it typed, the relevant portions, kindly,
In the
and then I will take to the
in the
89 rules.
In the petition?
In the petition, my lord, this I have not annexed. 89 rules I am taking to. The 89 rules, my lord, will find 89 rules have been amended. Now, 89 rules, lordship will find at page 81 of the writ petition. Those portions that were amended, I have got typed. Now, here, my lord, first of all, the rule 5. Unamended rule 5 may kindly be seen first, and thereafter the amendment, the type portion which I have given to your lordship. The rule 5, my lord, will find at page 82. In 89 rules. Unamended rule 5.
Page.
Page 82. Rule 5.
Yes.
Now, rule 5, sub rule 1, then A, B, C. After C, my lord, it's over here. But in 2023 amendment, Roman 1, Roman 2, Roman 3, Roman 4. The 4 categories have come. This my lord will see. Rule 5, 1C, Roman 4. The Roman 4 is very clear. And this I read. Arunachal Pradesh Police Service, within bracket anti-grade, post of sub-divisional police officer, deputy superintendent of police, stroke assistant commandant, armed police battalion, stroke assistant commandant IRBN, shall be filled by rule 1 of rule 12 and rule 26. So respective feeder grade. So if it is SDPO, Deputy Superintendent of Police, Inspector of Police Civil. If it is Assistant Commandant, Armed Police Battalion, then Inspector Armed Police Battalion. If it is Assistant Commandant, IRBN, it is Inspector IRBN. Respective feeder grade. This leaves no doubt. To that extent, board recommendation, yes. We bring in the Hayden's principle. What was the mischief? They rectified the mischief. But the problem comes, my lord, in the rule 50. The rule 15 of 89 rules. That was not amended. Page 85. Page 85, rule 15, appointment. All appointment to the service shall be made to group A or group B of the service and not against any specific post included in the service. So appointment is to the service, not to any specific post. My lord, we can read it in harmony with the rule 5. But prima facie, my lord, it gives them a scope. And this is what they are doing. So this is it. Appointment is to the service, not to any specific post included in the service. Now, my lord, in the amendment,
Please come again regarding 15.
all appointment to the service shall be made to group A or group B of the service and not against any specific post included in the service. That means, my lord, they are mixed up. It is assistant commandant, IRB and assistant commandant, armed police battalion, or it is DYSP and civil police. Makes no difference. Your appointment is to the service. Now, Lordship may kindly see this type portion, the schedule at last. The posts are provided.
Just a minute, just a minute.
This is group A service. Anti-grade, group A, no group A.
It is group A.
This appointment will also, the terminology appointment would also include a promotion, appointment by promotion.
It is promotion, my lord.
No, we are only
Yes,
concerned
with
with promotion.
It is also direct recruitment, yes, 50% by DR. But this is promotion.
No, we are concerned with the promotion thing, isn't it?
Yes, my lord, we are
Now,
concerned with the
15.
promotion.
15 says appointment.
Yes, but appointment is also by promotion.
No,
My lord,
that is what.
That is for lordship to say that.
That
That
is-
is why below the writ petition. I have understood the point.
That is what.
Yes, we can read that accordingly. But below it gives them the scope. And this is what they are doing. That is why, to be on safer side, the writ petition has come to interpret this. How do we do it? This is after the impugn WT message, the 23 amendment has come.
Let us just have a look at the
Now, lordship may kindly see the post also.
rule generally. Just a minute.
Because here probation is prescribed everything. So ordinarily, once it is by promotion, there is no question of any probation.
Right? You haven't given a copy to
Oh,
type
I'm sorry.
copy.
I'm sorry. I'm very
Yes.
sorry. Very sorry. If there is, let me see, Lord, if there is there extra?
Can we get a photocopy, sir?
My Lord,
Photocopy?
my Lord, I'm sorry, I made a mistake. It seems that the type copies have fallen short. I'm sorry, very sorry, my Lord. I'll get it subsequently photo stated. I'm very sorry. Don't have to stop. First blush, my Lord, this is also my understanding. It is not applicable so far as promotion is concerned. But the difficulty is,
This one. Let us just have a generally have a look. We're just trying to elucidate this from you or get. See, this 15, your apprehension is with regard to 15.
Yes.
Some mischief may be
yes,
created.
yes, yes,
15 comes under part 7,
yes.
which is with regard to appointment, probation, training and confirmation. If you turn over the pages or go back, so far as the methods of recruitment is concerned, it is under part 3.
Yes.
Okay.
Hmm.
Part 3, you have part 4 is of direct recruitment,
Yes.
and part 5 is recruitment by promotion.
Yes.
Okay. Now we again come to part 7, which is concerning, which also contains rule 15.
Yes.
Please come to 15. And we read the entire, just have a cursory glance of all the rules under part 7.
Yes.
Appointment,
Yes.
disqualification, no
Yes.
person who has contracted the marriage,
Yes.
spouse living, this is only with, has to be. only in
Apparently,
connection
prima
with
facie,
appointment.
yes, agreed.
17, probation, not for a promotee.
Well, yes.
17, 1, 2, 3, 18, training and departmental examination. Or
I go with my lord. This is my understanding also. But if it falls from your lordship, all doubts are removed.
yes, Mr. Tapping, what do you say? Instead of going for at this stage, we are not. saying anything finally.
Yes, it's also my understanding.
Prima facie, what we see from the rules, even without the amendment, he says that it will, it may come to their favor.
Yes,
It's up to you. That is not under challenge.
yes,
What is apprehending that 15 may still be an embargo or be an hurdle for being effectively implementing the amended part.
yes,
But 15, what we prima facie see is it only with regard to appointment.
yes.
And the rest of the rules under part 7, do you have the rules with you at page 85?
Yes,
This part 7 is appointment, promotion, training, and confirmation.
yes,
The rest of these rules under part 7 are all in connection with appointment, nothing to do with promotion.
yes.
So for the time being, we can say appointment here 15 can only mean appointment on a direct recruitment basis. It cannot have include promotion.
Lordship, so per part, this,
We want to get what is your what do you think?
Lordship, on page of
It's
the
your rules. You have
parts,
to interpret.
on the page of the part 7, Lordship,
Yes.
it seems what Lordship has observed, Lordship. To me also it seems, Lordship. But if Lordship see that the entire Lordship rules, Lordship, the Arunachal Pradesh Police Service has been classified into 4 categories, Lordship. That's classified in 4 categories, Lordship. That is, Lordship, the entry grade, grade 1, junior admin grade, and special grade, Lordship. When we say entry grade, Lordship, these all posts which are analogous or attached to this entry grade, once they enter into this service, Lordship, these rules doesn't make any difference, any distinction between from which sources you have come, Lordship. When it becomes the one common cadre, Lordship, then, Lordship, they becomes the part of cadre of the entry grade only, not against any post. Lordship. And this is the Lordship, what I understood from the entire rules, Lordship. If Lordship see the rules 22, Lordship. Next page, Lordship. Next
Yes,
page.
yes.
Rule 22. Posting of members of service, Lordship. Rule 22, Lordship. Every member of service cell, unless he is appointed to an extra cadre post or is otherwise not available for holding a post owing to exigency of public service, be posted against a duty post under Arunachal Pradesh. Duty post, Lordship. And what is duty post, Lordship? Duty post is given at page 81, Lordship, in the definition.
No, I must set up and say, having a common cadre is not the big problem. The
Lordship.
problem is how do you enter into the common cadre?
Lordship.
A person, see, there are, which we have understood, there are 3 segments:
Lordship.
civil police, Indian Reserve Battalion,
Lordship.
and Arunachal Pradesh Armed Police Battalion.
Correct.
These are the 3 from which you can come and be a part of the rules
Yes.
and form the entry cadre in the cadre of the inspector.
Lordship.
Having a common cadre is not the problem.
Right.
But how do you become an inspector? How do you become a part of the cadre?
Lordship.
If there is a discrimination
Lordship.
in adjudging or eligibility, suppose the admitted case, which have also been taken care of in the earlier by the earlier boards and the authorities,
Lordship.
is that in a certain segment of Indian Reserve Police Battalion, the career progression is faster.
Lordship.
So they become sub-inspector at a much early period. So their scope of being in the common cadre
Yes.
is more
More.
than a person who incidentally is one in a different segment.
Lordship.
They are aggrieved only by there. Having a common cadre is not the problem.
Lordship.
So for what you are saying, that once you are part of the cadre, it's a common cadre under say 89 rule, that's not the problem at all. But how do you come into the cadre? That is the issue.
Lordship. Lordship, in that connection, Lordship, if
And you have already amended the rules. You said that it will be in respectively. The word
Respective,
respective.
respective feeder grade.
Respect feeder grades.
Lordship.
So once you take into consideration their respective feeder grades while bringing them into the common cadre, it solves the problem. No one should get any undue advantage. No one should be also left out. Everyone should get an equal opportunity. That is what law says.
Lordship.
And 15, what we are saying for the purpose of today is only for the purpose of admitting this matter
Lordship.
and passing some interim order if it calls for. If we have a prima facie view that 15 per se will not have any impact on the forming a common cadre, because it's not an appointment,
No,
it's a promotion.
promotion.
And 15 and the rest of these rules under part 7 are essentially or intrinsically connected with an appointment per se. Because the rest, 16, 17, 18, probation and how your appointment can be governed. If that is your understanding also, just today it should not be there should not be much difficulty.
Lordship, at this stage, Lordship,
No question.
এখানে 94 এগুলো 94 তে 74 এবং 5 আবাদে পাইছে
Career progress to support. It will have
কিন্তু ফিডার এটা প্রমোটে এগুলো বহুত হয়ে গেল আর এগুলো হুনকালে পাই এখানে ইন্সপেক্টর তো এটা হুনকালে পাই যাবে আমার রেসপেক্টিভ ইয়ার আমার ইন্সপেক্টর হতো এখানে মধ্যে সকলে আমার ইন্সপেক্টর এখানে সকলে এমএলএ ইন্সপেক্টর এখানে সকলে এটা হলে এখানে তেমন কম্পিটিশন মানে এমন কম পিরিয়ড সার্ভ করতে এগুলো কম্পিটিশন করতে আর 15 তে খুব ক্লিয়ার করে দিই আফটার এ board minutes of meeting respective federal senior citizens eligible officers. If you tender to February, 15 of February, the 15 day the question page section. All appointments shall be to the services shall be made in group or group of the service and not against in 15 all appointments are from 15 is a part of is a part of part 7. Part 7 of assessment itself, all are in connection with appointment, nothing to do with promotion. Is a probation. Normally, to promotion of probation of appointment is disqualification.
Lordship, one proposal from my side, Lordship. As per in terms of the earlier round of litigation, that direction was given by the Honorable Division Bench to examine accordingly examine when the matter is pending before the authority, Lordship. Can it be disposed of directing the
No, no,
authority?
we're not disposing of whatever has been done. We were not following that practice of disposing.
Then, Lordship, I may be allowed to take instruction in regards
Come to
to
the court challenging the correctness. Why should we again without examining?
Lordship.
Professor, we have to be satisfied that there is something to be disposed of, to be remanded back.
Lordship. On two aspects, Lordship. Partly, Lordship, the term respective has been used in amended rules, Lordship. In that regards, what does it mean, Lordship? One. Then second is, Lordship, whether this rule 15 is applicable to promotion or not.
See,
On
Mr.
these two
Mr.
issues,
Tapan, Mr. Tapan, your
Close.
first submission, what respective mean or not, that we need not even go into because they are not even challenging the amended part.
correct, Lordship.
They are only thinking that 15 may come into the way
Yes.
of executing or implementing the amended portion.
Close.
Will, for the time being, will say that 15 appears to be only with regard to appointment and not for promotion. You go ahead. And whatever your action you take, it will be subject to the outcome. The virus, it may not be even required to be gone into the virus of 15. You're only challenging virus of 15.
Yes, my lord. But my lord, in the teeth of 2023 amendment, whether the
No, you can
WT
read,
message.
You can read down 15. You can explain.
No, my lord, that is true.
Ah.
But WT message which contains 54 names. No, my lord, therein lies the whole problem. They are considering
Where is the WT message?
WT message is dated that I have pointed out, my lord. The WT message is
1411.
14/11/23.
Where is it in the new petition?
In the writ petition, my lord, it is in the present writ petition, it is challenged.
Where? Page?
Where is my? Page 135.
But that is already under stay.
Yes,
in
that
the
is under
IAC.
stay.
So what? And there is no vacating application.
Yes, very well, very well. That's.
Lordship, Then on Thursday, Lordship, on this, whether it applicable to the promotional post or not, Lordship, the Rule 15, Lordship.
No,
Because
you-
under challenge, Lordship, if any decision is taken or any observation is
see,
made.
their challenge, their perception may not be our thinking also. We may think that 15 is not even in, there is no contradiction. If 15, we hold that it only pertains to appointment, not for promotion, recruitment by promotion. Because what we have already, we are again repeating, the rest of the rules under part 7, if you read, it is pertains to only to a fresh appointment, not for recruitment,
No,
not for promotion.
What I'm submitting is that, Lordship, if that part, if we decide today, Lordship, then Lordship, matter will.
No, we are not
Matter-
decide, we cannot decide. We have not even heard it properly.
So therefore, I'm submitting Lordship, since the Rule 15 is under challenge, Lordship, whether it's applicable or not. If it's not applicable at all, Lordship, then this the purpose is already
No,
served,
no,
Lordship.
no,
Then on.
these are matters of grave importance. Without a proper hearing and
No.
without your instruction, we are not going to dispose this of.
So-
We'll hold that prima facie does not appear to be connected to a recruitment
Yes.
by promotion.
Lordship.
And therefore, you go ahead along after.
No,
the
what? That observation will have some Lordship, consequences, Lordship. So therefore, before that observation is made, because that observation will decide very the purpose of filing this writ petition, Lordship.
Now, if you don't make an observation, what is the purpose of sitting
No,
here?
Lordship, liberty is always there,
Person has
Lordship.
come to the court to
No, what
have
I-
a judgment.
What I'm
If you
praying,
are not,
no, what I'm,
if you are precluded from making an observation,
Lordship,
and we can then pass an order, not an observation.
Lordship, what I'm praying is, Lordship, I may allow to take instructions on the applicability of Rule 15 before any order is passed. Thursday, this is my prayer, Lordship.
If it is agreeable by the council, why not? Yes.
Otherwise, Lordship is always liberty.
Well, we'll pass orders on Thursday. Your presence may not be necessary. I've heard you in length.
I beg your pardon, I couldn't follow
He
the.
says that the prima facie view which you are trying to, which you have just expressed, whether
My lord, so long
15
as, so long as they don't act upon the WT message,
they
it is
cannot,
under,
there is a stay order.
that is why, so long as I am protected, I am not
There
worried.
is a stay order.
So long as I am protected, I am not worried.
Mr. Perme,
Yes, my lord. Yes, my lord, in the past, I think, my lord, I have, this, I may be not, had no say, my lord. In the item number 3, my lord. My humble submission, my lord, there is IA, my lord. Now, that is yet to be allowed, my lord. Now, in absence of IA being allowed, my lord.
three is item number, 3 is which item?
Three.
So that's amendment application.
Amendment.
We are amending the old writ petition,
Yes.
bringing in all the new facts.
That's why, my lord.
20C amendment, everything.
IA, my lord. The IA is amendment, my lord.
I know, since as a matter of abundant caution, a separate writ petition has been filed
Filed.
challenging 15,
Right.
queries of 15.
Right.
So, allowing the amendment is only a formality, it's before us.
No,
it's
no,
before
that,
us
my
for
lord,
consideration.
yes, my, that is totally up to discussion, my lordship, my lord. But by my humble submission, my lord. Now, the intention, my lord, I to amend my lord, this way, my lord, challenging the recruitment in this way, my lord. That totally prejudice me, my lord. How, my lord? My lord will see, my
You
lord,
have filed your objection.
my lord, while my lord, on that last occasion also, my lord, I humbly submit, my lord, I'll argue verbally, my lord.
No, without your pleadings in this kind of matters, you can take a risk, but without pleadings, from where are you arguing?
From the record of my lord,
You are
record
not the
available.
state, you are a private respondent.
Yes, my lord. I'm
Private respondent, if you are, depending on the record of the case which is placed before us, it's up to you, but without
Yes,
any
ma'am.
pleadings.
But that my lord totally, my lord, today my lord will give me 5 minutes, my lord.
No, Thursday we are hearing the matter.
My lord,
Thursday, the London State Council has prayed for time. Otherwise, if you hear, you will pass the orders today.
my lord, other than my lord, the interim order, my lord, I have challenged in the item number 4, my lord.
Or is the new petition?
Yes, my lord. 4 I have
New
challenged.
petition which is yet to be admitted.
That time, my lord, give me 5 minutes. My lord, the
So
case,
what is the difficulty in filing your pleadings? Aren't you required to file your pleadings? Why should we allow you to argue without pleadings? Tell us. Why don't you file your pleadings?
yes, my lord, all the necessary, my lord.
Now, why don't you file your pleadings? What is the difficulty? Tell us. Your client has asked you not to file pleadings.
That instead of filing,
Virus of a rule is challenged, you are saying that you will not file pleadings. You are a private party. On what basis will you argue? Where is the basis? Where is the foundation of your arguments? What are pleadings?
my lord, that's why I'm praying for humbly, my lord, 5 minute time, my lord, so that I could place my foundation, my lord, in this case.
Oh, that is what we are asking you. How do you argue without your pleadings? What 5 minutes? We'll give you 50 minutes. But put the pleadings on record. File it tomorrow. Thursday we'll consider.
My lord, only one difficulty. On Thursday, my lord, in Guwahati principal seat,
No,
they have
but,
fixed a very old, they have fixed a very old case. And my lord, they will not.
Leonard Senior Government Advocate has prayed for Thursday. We're only trying to accommodate him.
Please,
Otherwise,
because
you
it's a
don't
very
have
old
to-
case. My lord, it's a 2015 case. High Court will not give me time.
May I pray that, my lord, I may be to allow to argue on the item number 4, my lord. Yes, I have interim period here, my lord.
Item number 4 is your petition.
Yes, my petition, my lord.
For vacating the stay order.
Writ appeal, my lord.
Huh?
Writ appeal, my lord.
Writ appeal.
My lord,
Against the, my lord.
challenging
interim order.
the interim order of Justice Fukan, they have filed the writ appeal.
Oh,
It
there is
seems.
a writ appeal filed by you. You can argue on that. Where is item number? What is the name? Okay. Is it 1 of 24?
Yes, my lord. Now, my lord, before coming to impugn order, my lord. What happened in this case, my lord? My lord,
You are challenging what? You are challenging 2112.
yes, my lord, 20 and 12, my lord. Yes, sir. Lord, before coming to impugn order, my lord, what happened? IAM, this IA is filed on WPC number 40/2021, my lord. Now, in the main, my lord, contention, my lord, in WPC 40/2021, my lord, by the petitioner, my lord, is against the appointment, my lord, in WPC 405, my lord, what happened, my lord? The government, my lord, fill up 19 posts, direct posts, decided to fill up 19 direct posts, my lord, through promotion, my lord. According to decision was made, my lord. According, they are promoted, my lord. Now that was challenged by the petitioner, my lord.
You were promoted.
No, we are not, my lord. We are no in
My lord, I'm not
WPC.
pressing that part. I have abandoned the
Yes, my
prayer.
lord. In WPC 405, we are not there, my lord. Now, my lord, they challenge that, my lord. And already senior counsel has submitted, they challenge the joint seniority list, my lord. In WPC 405, that was the main case in W0405 2021, my lord. Now, in
05 of 2021.
21, my lord, they challenge, my lord, those appointment, my lord. Appointment of the private respondent, my lord. No, we are not there, my lord. We are not a party till that, my lord. Now, in between, my lord, this WPT message, my lord, was issued, my lord. For, my lord, promotion to another, my lord, 20 posts, my lord. 20 posts, my lord.
You were
We were there, my lord.
for another 20 posts.
Another post, my lord. The chapter related to 205, 405, my lord, close, my lord, as my lord, there was no interim order, my lord, they are appointed, my lord. Now,
The IA 203 of 2023 is in connection with WP.
405, my lord. My lord, that is my humble submission, my lord. Now, I file a IA, my lord, 203, my lord, challenging that W3 message, my lord. Now, that W3 message has no related with the WPC 405, my lord. in WT measures, our name were there, my lord, including the name of the writ petitioner, my lord, in the 405, my lord. All name were there, my lord, including their my lord, writ petitioner, my lord, in the 405, my lord, and other, my lord, person, my lord. As much as my lord, 50%, including the writ petitioner in the WPC 5, my lord. Now, my lord, as my lord, we came to know that we filed, my lord, IA application to impede us as a writ petitioner. As they are challenging a WT mission, my lord, any order will affect us, my lord, we accordingly impede ourselves, my lord. Now, the way, my lord, this order, my lord, in the IA 20, my lord, purpose, my lord. Now, my lord, in the my lord, kindly appraise, my lord, the subject matter, my lord, in WPC 405 2021 was about, my lord, mainly about the appointment of the in the 19 post, my lord. Earlier 19 post, my lord.
Okay.
Now on the now my lord has had the land senior consent. Categorically in the category term they have said they have dropped that prayer, my lord. Now their main prayer in the WPC gone, my lord. WPC 405 to 2010 gone, my lord. Now in term of my lord, my humble sir, in term of IA, my lord. Whether the my under course of action, my lord, can be challenged, my lord. WT Mrs. My lord will kindly have a look, my lord. I have to enclose, my lord. Page number 2.
21 where 2022 I
Concept order taken, huh? I, अपना
order tonight.
division bench order में कोई duplicate कोई का second pattern ना था, तो क्यों मतलब?
Itu baru dah pernah dilihat.
ये order division bench तो वही था,
Ini
पहले
second
बोले
order.
ना।
Itu order tonight tu ya dia.
ये तुम्हारा काम है, ये तो इसकी ना था वो। फोटो कॉपी এটা कोई ना कोई दे दी तो।
Kita division bench sekali.
अपना रेट देखा तो 224 second petition का था 24 का था
Where is that interim order in the new writ petition?
Oh,
Which page?
yes.
In 24? The order dated
Yes.
21/12/2023.
So it is annexure P19,
Page
142. There was impediment also. Many private parties got impeded. And my lord, there were multiple prayers in WPC 405. Prayer number 1 and 2, I am no longer pressing. Other prayers survive. I'll point out that.
Okay.
Mr. Parmay, you are trying to contend that the cause of action of 405 is totally different
My lord.
than the cause of action which is now sought to be raised by form of an IA 203.
My lord.
And therefore the IA may not be maintainable.
My lord.
That is
They
what you are
they
contending.
pass ground, my lord. Now, my lord, if my lord in IA, my lord, my lord, have kindly look at this WT message at page number 282 of my petition, my lord.
282.
82, my lord.
Yes.
Now, my lord, yes, my lord, this is regard promotion from the rank of Inspector Civil Police, APPIR into APC's entry kit, my lord. Now, their main grievances, my lord, here is that this this WT measures, my lord, does not classify how many posts, my lord, is of IRB and my lord, APP and my lord. They are that's why, my lord, their main grant to challenge, my lord. This, my lord, WT message was, there is some ambiguity, my lord. Now, my lord has seen the amended requirement rule, my lord. Already amended requirement, my lord. That, my lord, dear apprehension, my lord, I humbly believe has gone, my lord. Now, this requirement will specifically say, my lord, to the respective IRN, my lord. Respect or restrictive cadet, my lord. Now, there is no chance, my lord, that we, my lord, suppose, so IRB, my lord, will be promoted to, my lord, in place of the, my lord, APP or civil, my lord, and IPPBN, my lord. Now, that issue, my lord, also hand gone, my lord. Post, my lord. Therefore, my humble submission, my lord, this, my lord, need not to be, my lord, this interim order, my lord, need to be interfere, my lord, and this WT, my lord. Let the respondent, my lord, state respondent may continue with the process, my lord, and my lord may can make the observation, my lord, if they are now this recruitment rule, my lord, amended recruitment 2020 is not under challenge, my lord. My lord, if they have a present, my lord can make an observation in regard to the rule 15, my lord, say that may be not applicable in the case of promotion, my lord. Now, my lord, what, my lord, in this case, my lord, the petitioner, my lord.
This amendment was which date of amendment?
Amendment, my, also I have enclosed here, my lord.
Date.
7/12/2022, my lord.
7/12/2022.
23, my lord.
7/12/23. This is after the WT message.
Yes, my lord. After WT message, after the interim order.
My
Interim
lord, it
order.
was notified on 28th December 23. 28th December 23. Notified. Published in the Gazette notification.
That means admittedly after the WT message.
Yes,
My lord.
yes, after. After WT message, after the interim order of the Honorable Court.
My lord, my humble submission here, my lord. What, my lord? The
You belong to which segment, Mr.
IRBN, my lord.
IRBN.
Now, my humble submission, my lord, in this whole case, my lord, what the, my lord, petitioner, my lord, trying to project a case that the civil police, my lord, is the victim, my lord. Whereas, my lord, we are the ultimate victim in whole this process, my lord, IRBN, my lord. How, my lord, will kindly note in this case, my lord, our appointment, my lord, our appointment vis-a-vis civil police, my lord, were made through a combined recruitment process through a merit cum choice, my lord. Now, all this recruitment rule, my lord, when we are appointed, my lord, all this is dear, my lord. Now, merit the ultimate way, my lord, to appoint the post where the merit comes as, my lord. The person who made top the merit will given the pass as, my lord. Now, that process all were appointed, my lord. Now, all this recruitment, recruitment, my lord, process was there, my lord.
Yes, what we can balance it. We can, so far as this, we're just tentatively thinking aloud. There is an interim order of 21/12/2023 in the earlier proceedings, where based upon your apprehension that 15 may play a mischief. So it has been stayed. We can
By Justice Fukan's order.
Justice
Justice Fukan's order.
Honorable Justice Fukan's order. We can clarify that this recruitment drive by 282, this WT of 14/11/2023, there will be no restriction to go ahead with this recruitment drive.
It's not a recruitment, it's a promotion, my lord.
That is a promotion drive, which either that you have to do strictly in accordance with the amended part of the rules, wherein the respective cadre that will be taken into consideration. Because en masse we cannot stay a promotion process. It may not be in the interest of justice. In this matter which you are contemplating, the interest of all the parties will be taken care of.
But my lord,
And we
before,
may also say, because he's yet to get the instructions, that before you make any final orders of promotion, we pass appropriate orders. It will not be done in 2 or 3 days. Thursday is going to come back regarding their understanding of 15.
but Thursday, my lord, it will be very difficult for me to
We
be
can
present.
fix another day. Another
Because
day.
Thursday.
We'll say that process, there will be no harm. You go ahead with the process.
But without leave of the honorable court.
Don't issue promotion orders.
Without leave of the honorable court. Very well. That's good enough.
Because, see,
And my lord, in terms of 23 amendment, they will act.
yes, sir, that will.
And without leave of the honorable court, they will not pass the final order.
They have to otherwise also abide by the statute.
But their understanding of rule 15 creates a problem for me. That is why I have come before the honorable court.
Replicate your London Senate Council. Assisted by who's there? Mr. Tate Agum. You are hiding? Afraid of Mr. Parme?
No, my lord, it's a client interest matter.
Client interest, you are hiding. He is a very otherwise gentle and docile person.
My lord.
Don't be. Also heard. We messed up in the learned senior government local AP. Put up. 3. L purpose. Learned council. Is present for.
My lord, in past item I'm yet not authorized, my lord, to item number 2, my lord. This is a new, my lord, in most. My case, sorry, my lord. In detail, my lord.
In the department, learned council is the learned council appears for the appellants. In writ appeal 1 of 2024.
My lord.
You, what is your name? For? In which one? 405. Then before you went right to 24, write his name. Then you write separately 24 for me. Both these writ petitions and the are connected, in which there are a number of interlocutory applications also. Full stop. There is a checkered history for filing, a checkered history in these cases, which has also culminated in filing WPC 24 of 2024, whereby the virus of Rule 15 of the, what is the rule? So rules have been challenged with the apprehension that such rules are in conflict, would be in conflict with the amended rules of 2023, more particularly Rule 5 within bracket 1 within bracket C within bracket small 4 small 1 4 full stop. Para. Without going into the details at this stage, comma, this court notes that in the year 2012, a writ petition was filed challenging an amalgamated seniority list of inspector, which was done for the first time. Full stop. It is contended that in the state of Arunachal Pradesh, comma, there are 3 segments concerning the police, namely civil police, number 2, Indian Reserve Battalion, number 3, Arunachal Pradesh Armed Police Battalion. Full stop. It is submitted that till the cadre of the post of inspector, comma, the rules in the three segments are different. Full stop. However, comma, in the Arunachal Pradesh Police Service Rules 1989, comma, within bracket hereinafter called the rules of 1989, bracket close. A common entry grid has been created. Full stop. The aforesaid writ petition 42 of 2012 was disposed of by this court while in order dated 13/5/2015 by remanding the matter as it was submitted on behalf of the state that the same was under consideration before the appropriate authorities. Full stop. Consequently, comma, the appropriate board wide by notes of meeting dated 9/10/2015 took into account that the career progression of the officers in the different segments were different, and therefore the board recommended that the post of that the what is it, entry cadre under the rules should be filled up by taking into account respective seniority. Full stop. It is contended by Sri Tiwari, the London Senior Counsel, that in spite of such recommendation, comma, a WT message was issued on 17/10/2017, whereby 40 names of inspector was recommended, which appeared to be a consolidated list, and thereby it appeared that the recommendation of the board was not implemented. Full stop. Para, being aggrieved, comma, WPC 20 of 2018 was filed. Full stop. The said writ petition was, however, disposed of by this court while an order dated 29/1/2018 whereby the representation said to have been submitted was directed to be disposed of. Full stop. In compliance of the said order, comma, a speaking order was passed on 5/11/2018, with the recommendation that the rules were to be amended and the combined seniority list was not approved. Full stop. The government, however, thereafter published a notification dated 8/10/2020, whereby approval of a common cadre with prospective effect was given. Full stop. Though on 13/9/2023, a separate seniority list was published, comma, wide a WT message dated 14/11/2023, comma, 54 names of inspector belonging to all the three segments were published. Full stop. It is submitted that out of the 54 names, comma, 26 belong to the civil police, comma, 20 from the IRBN, and 8 from the armed police, from the AP Armed Police Battalion. Full stop. As the representation by the petitioners in that case dated 21/11/2023 was not considered, comma, IA 203 of 2023 has been filed, in which this court, by an order dated 21/12/2023, had stayed the WT message dated 14/11/2023. Full stop. Para. In the meantime, comma, WPC 24 of 24 has been filed by a group of another persons challenging the virus of Rule 15 with the contention that the said Rule 15 would be in conflict with the amended rule so and so.
And will not be able to challenge the WT message.
Uh,
WT is also.
That apart, comma, the validity of the WT message dated 14/11/2023 has been specifically challenged. Full stop. Para. 3. S. Tapin, learned senior government advocate, has submitted that on the submitted that though where are the rules? Which page? Though Rule 15 of the rules of 1989, which is under Part 7 of the rules, appear to be ex officio appear to be connected with an appointment, comma. He prays for some time to take specific instructions as to whether the said rule would also be applicable in case of promotion. Full stop. He submits that in case the aforesaid Rule 15 would not have any connection with a promotion, comma, the entire challenge may not be even gone into, may not be even required to be gone into. Full stop. As regards the WT message dated 14/11/2023, comma, he submits that apart from that, though there is an interim order dated 21/12/2023, comma, the same may be clarified by this court with a direction that recruitment, that the promotional process may be done strictly in accordance with the amended rule so and so. Sri L. Parmin, learned counsel, who has separately filed WA 1 of 2024 against the order dated 21/12/2023, has submitted that the said order was passed in an IA 203 of 2023, and the subject matter of the IA was not at all connected with the original writ petition 405 of 2021. Full stop. He submits that the present appellants were not the parties in the said writ petition, and the original writ petition was on the aspect of appointment by promotion to 19 numbers of posts, whereas the subject matter of the IA is on a different cause. Full stop.
We don't have to clarify
Para-
all this. We
para-
don't.
Sri Tiwari, the learned senior counsel, however, submits that it is not the matter of filling up of 19 posts by promotion, which is the only subject matter of challenge.
Yes.
And the writ petition W 405/2021 also contains other reliefs which are yet to be finally adjudicated. Full stop. Para. Since as the London Senior Government Advocate has prayed for some time to obtain instructions, we deem it fit that the matter be taken up on the next date, and be adjourned to a next date to enable him to obtain the instructions. Full stop. However, by balancing the equities, this court we are of the view that instead of a blanket order of stay of the entire process, the order dated 21/12/2023 stands modified by giving liberty to the respondent authorities to go ahead with the promotional process, which, however, has to be done strictly in accordance with the amended rules so and so, whereby there is a requirement to assess the eligible officers from their respective feeder grade. Full stop. It is further directed that before issuing final orders of promotion, leave of this court may be taken. Full stop. Para. As requested, list on Thursday.
Thursday, my lord, I cannot, my lord, no adjournment will be given to me.
Monday.
Next
Monday,
month?
yes.
Next month.
Monday, just a minute. Could it be on?
No, now there will be
My
no,
lord,
there is no hurry. You can go ahead.
My lord, they can always, because, no, here. Not kindly. Where is?
Let there be a date of your consensus because
Yes, my lord,
Give
12th,
some
12th I am
time.
free. Monday I can come.
Monday.
But my lord, amendment may kindly be allowed because now there is no problem for the amendment application. IA is also there, my lord. My IA for amending WPC 405.
Sir,
My lord, it is important. There is a reason. Amendment can be allowed at any stage.
also for further consider for when the matter will be further considered. No, so don't tell. That may lead to a part thing.
So my
Further
lord,
consideration.
my lord, kindly the amendment,
Huh?
the amendment, IA for amendment.
Sri P.K. Tiwari is that London Senior Counsel would be at liberty to press ISO and so, which has been filed for amendment on the next date.
Okay.
Common order. Huh?
2, 3 and 4.
Okay, this matter.
Yes,
is
sir.
out.
Yes, sir.
Okay. We can hold the service to be complete then? Notification for double duplicate property. Degrees of the
Lordship, there is a two interlocutory application here. One is for condemnation of delay. The ground shown by this, as per the condemnation of delay application. There is 156 days delay in filing criminal appeal. And the ground of delay is in page 5, para number 3. Here is the convict is the sole bread earner of this family. And he has been convicted and is due to abject poverty. He could not.
You are addressing which matter?
This,
Item 30, the 39 or 40?
This, I number 40.
40 you are addressing.
40. But 39 is.
I number 40.
I think you are pressing 39.
39, yes, no.
39.
Condonation.
39.
39.
Down is due to abject poverty. He could not manage this. Yes, that is why this at the very belated is the case is filed. So, in the interest of justice, this
So who is the appellant?
appellant is
Mother of the
mother
accused.
of the mother of the this convict,
Convict is a minor or what?
not
Not
minor.
minor.
Major is the husband of.
Why isn't the appellant registered in his name?
Lordship.
Why isn't the appellant in his name?
Actually, it should have been in the name of this Asai Wangpan. This is convict is 24 years. Convict. But
Why-
case has been registered. This case has been kindly see the page number 3. Filed through Rita Manchat Wangpan, mother of the accused person. Mother of the accused person.
Why true mother?
And wife of. Two names is
No, no,
written.
this is a private appeal, isn't it? Or it's a
Ye-
jail appeal?
Private.
Jail appellant.
No, no, it's a private.
Private appeal, isn't it?
Yes,
Come to page 2,
page 2.
page 2.
Is that
State of
versus
Arunachal Pradesh versus so and so. Convict.
Asai Wangpan, convict?
Okay, this ends here.
Yes.
Through.
Through,
Where is the appellant? Where is your cost title?
kindly see, page number 3.
This is not cost title. Cost title has to be you versus the state.
Yes,
This is what you have written in the, this is regarding the POCSO case in the trial court.
yes. This is,
Where is the appellant?
appellant is Rita Manchat.
How do you have, where have you stated? You see, it's a start at page 2, state of Arunachal Pradesh versus so and so
Asai
convict,
Wangpan, yes,
so versus so and so appellant. This is not
Yes.
how you may add a party.
yes. This is
Appellant
the
has to
party,
come first.
this is the party name of the party during the course of trial.
If you do not know, ask the registry how to add a parties. You have written versus twice, how can be versus twice? In this court, you have to make separately parties, the appellant versus the state.
This is not exactly lordship, this is convict versus state.
Where?
Kindly see page
Then
number
what
3,
about the first part, Arunachal Pradesh versus convict?
page number 3, kindly
Why,
see.
where is the separation of page number 2 and 3? We are not supposed to teach you all this. And don't drag this forth to all these controversies. You know what we are meaning, and don't try to drag this. We don't like this kind of attitude. Why don't you admit the mistake? Aren't you supposed to write separately?
I may be allowed to correct.
No,
it.
no, you maybe, but it's a mistake. Appellant has to be first, then versus so and so.
Yes, yes.
You have not separated. And only because you have written through Rita so and so, the appellant has to register in the name of the mother or mother of the accused.
Actually, lordship,
Yes, it's state versus.
lordship,
State versus, and then again second.
this
So,
is a convict. Convict has authorized his mother.
Mother can sign the wakalatnama.
Yes.
The mother will not be an appellant. Appellant needs to sign the wakalatnama. Mother can sign the affidavit or whatever. The
Yes.
wakalatnama has
Yes,
to be
sir.
signed by the convict
She has
from the
signed.
jail. Okay, doesn't matter. These are criminal matters. What is your explanation? How much is the delay?
Explanation is 156 days.
Yes, madam?
His lordship,
Clear it with-
yes, yes.
For this item number? T Tapa, learned counsel for the applicant. Who by means of this application has paid for condonation of delay of
156 days. Your
156
156
days
days.
in preferring the 156 or 185.
156 days.
What is the calculation of the office? You have written 185 in the prayer.
156 days.
Where do you get?
Here. In prayer portion, as well as in the constable also, you have written 185
185 days.
Is it
Maybe-
185
maybe
or 156?
Yes. Filing assistant has corrected the record. Maybe. As per my
Subsequently
record.
corrected.
Court records, there is whatever is there is.
156, I have in my record, 156.
Mr. Tapa, what you are holding is not the record. What we are holding are the records.
Yes.
If there is no correction here, whatever correction you make in your copy,
Yes.
will it make any difference?
Ma'am, Make it 156, 108.
Officer could calculate.
Yes.
probably.
What is officially has been filed. That may be.
Officer calculate করবো লাগে না?
What's your calculation? पहले कहाँ से लिया? सबसे कहाँ से लिया? Calculate कहाँ से लिया? से calculate करा।
काम ना हो रे लोग समझ लो। আমার থেকে তো ক্যালকুলেশন তো করে বলে গেছে দেখো বলে গেছে বা রাস্তা দেখো
Last page तो ठीक है।
वो है कि वो এটা বস্তু দেখা বলে করে স্প্রে
Ms. Jeannie, where from you are saying that it is 156? Have you calculated that one?
No, your lordship. My petition, it's
No,
one,
petition is not there. What is the calculation?
Calculation in what?
156 days.
Which will not.
ৰাস্তা এটা ডাঙৰ কথা হৈছে ডিভিজন বেঞ্চত অৰ্ডাৰ বিলাক ছেকেণ্ড কপিত নাথাকে কিয় যি অৰ্ডাৰ থাকে নাই এইটো অৰ্ডাৰৰ কপি এটা ছেকেণ্ড কপিত থাকিব লাগিব নাই দিয়া নাই আৰু এইটো ডিলে কণ্ডিশ্যন আপোনালোকে ডিলেটো ক'ৰ পৰা হেৰি কৰিলে তেওঁ যোনটো দেখিছে ক'ত আছে কেলকুলেশ্যন এইটো 156 বুলি লিখিছে 156 হয় নহয় কেনেকৈ জানিম
আইএটো আছে নেকি?
আইএটো আছে আইএটোতো একোৱে নাই নাই কাৰণে মই আমাৰ যেনেকৈ ইয়াতে চাইডত ইয়াতে ৰাষ্ট্ৰত বা ইয়াতে অংক কৰি থৈ দিম এতিয়া একো নাই নহয় ক'ত পৰা আহিব বাজেট কাৰণে আমি ক'ৰ পৰা এডজাষ্ট কৰিব কম হ'ব পাৰে বেছি হ'ব পাৰে
চেক স্লিপত একো লিখা নাই। একদম কম দেখা।
একদম নহয় আমি দিম কিন্তু এই বছৰ বছৰ চলিব লাগিব কেলকুলেশ্যন এসে কৰিব লাগিব
আচলতে এইটো মোৰ তাত নাই মই থকা
আৰু এই অৰ্ডাৰ কপি ছেকেণ্ড কপি নাই ডিভিজন বেঞ্চত এভৰি অৰ্ডাৰ হেজ টু বি দেয়াৰ হেজ টু বি
নৰ্মেল কথা ঠিক আছে মানে
এইখিনি বস্তু লৈ যাওক আৰু কিবা থাকিব পাৰে দুপৰীয়া মই কথা পাতিম ডুপ্লিকেট কপি অৰ্ডাৰ ইন দ্য ছিগনেচাৰ্ছ ফাইল ডিলে কণ্ডিশ্যন to be done by the office which can be seen from the records. Yes, yes, what did we write? Of delay. Delay. So, though the delay has been stated in the petitions to be 185 days, the Learned Council has clarified that the delay is of 156 days. Full stop. By referring to the amendments made in paragraph 3 and 4, 2, 3 and 4, comma, the delay has been sought to be explained. Full stop. This judgment is of December 2021.
Yes,
Okay, well. Yes. Gaining the learned disabled people subjects that she would not have serious objection as the appeal is from an order of conviction.
15 December.
Considering the aforesaid, comma. This court has seen the grounds by which the delay has been sought to be explained. Though the grounds do not appear to be chosen, comma, considering that this appeal is from an order of conviction, comma, the delay in preferring the appeal is condoned. I is according to this process. I is according to this law. In the way to release the appeal for admission after a week.
Your Lordship, since the service has also been complete, if the LCR is being called for, Your Lordship.
We are yet to admit the appeal. The criminal appeal.
Yes, Your Lordship.
May I plead, Your Lordship? This PIL, it's related to installation of stone crushers, which was installed in violation of the guidelines, and then
Is your response?
Your Lordship, we have,
Right.
no, not yet filed, Your Lordship. We need some more time, Your Lordship.
When did you file the PIL?
which was filed on 12
October.
October.
Yes, Your
Filed it
7th.
we are
from almost 4 months have passed.
Your Lordship, 3 more weeks may be granted to us, Your Lordship.
Actually, for
I'm for respondent 9 and 10, Your Lordship.
you're the one of the stone crusher.
Yes, Your Lordship.
What is your view? Have you?
Respondent number 9 has already filed his.
Your
uh,
filed your
Yes,
affidavit?
yes, Your Lordship.
But
As for
you have
respondent
got
number
a
10,
copy?
no, I have not got the copy.
You have not served copy of me.
Today itself.
You're filing it today.
No, I will provide one copy to
Where
you.
did you file?
25th, this month.
Okay.
Yes, Your Lordship.
Those the private respondent was 9 and 10.
Yes, Your Lordship.
9 and 10 have filed the affidavit in opposition on 25/1/2024, comma.
Your Lordship, only 9 has filed. Number 10 will file.
Oh, the learned counsel appearing for the respondent number 9 and 10 submits that the affidavit in opposition by the respondent number 9 has been filed on 25/1/2024. Where, full stop, that copy be served upon 3S now, learned counsel for the petitioner, full stop. The state, however, is yet to file the affidavit, full stop, para, on the prayer made, comma, list after 3 weeks to enable the remaining respondents to file their affidavit.
Legally inclined.
3, now the learned counsel for the petitioner may also file rejoinder to the affidavit of the respondent number 9. One minute.
Contact matter, may I please, my lord? My lord, in a land acquisition proceeding, my lord, award was passed, my lord. However, no solution and the interest was given in the award, my lord. So we filed a writ petition before this honorable court.
Now, what is the office note?
Hmm.
Who is the sole respondent?
My lord, the secretary land manager, my lord,
Secretary land manager, why not served?
who's taking the steps, my lord. By now, my lord, incumbent secretary has changed, my lord. So
File an I.
I will file an I, my lord, including the new.
But that will not preclude or absolve
Yes,
the earlier.
yes, yes,
He
yes.
has to show cause.
My lord.
We are saying, learned counsel for the petition, submits that the incumbent who was holding the post
Secretary land manager.
of the secretary, comma, land management has changed, comma. He according to praise for and is granted 2 weeks time to file necessary IA to implement the new incumbent. Full stop. It is however made clear that implement of the new incumbent will not automatically absolve the earlier incumbent from the responsibility. The earlier incumbent from the purview of this petition. And he needs to explain regarding the steps taken during his tenure
Mine.
towards compliance of the order of this court.
Yes.
May I pray for listing tomorrow, my lord, as admission?
Fresh matter.
No, my lord.
What is the urgency?
Urgency, my lord, affidavit has been filed, pleadings complete, my lord. And since to October, it's not been listed, my lord.
Okay.
Oblige, my lord.
Yes. Yes. You're for the department?
Yes, I am for the department. I've taken conscience.
Twenty?
3.
On the prayer of 3. G. Tarak Leonard, Standing Council, RWD. Matter is adjourned by 3 weeks
3 weeks.
to enable filing of affidavit of appeal.
Obliged.
Yes,
My lord, I beg to mention item number 17 and 18, my lord.
17, 18, yes?
Yes, with the consent of the other party, my lord, can this matter be listed on 15th February, my lord? I'll take instruction from the authority, my lord.
My lord, item number 3, there is interim order, let me.
Item number
23.
23, which has been mentioned just now.
Just now,
Mr. Tarak? There is an interim order in that your case.
Okay.
Interim order passed earlier, stands extended till the next date of listing. There's an interim order. We're extending that. Yes. Here, yes. What is
17 and 18, my lord.
21, 17 and 18.
Endeavors shall be made to.
My lord, they have consented for on 15 February, my lord.
15 February.
Lordship,
15 February is a holiday,
Oh.
I've been told.
then 16. 16.
16, my lord.
16, is it okay? 16?
16, okay.
The bomb, 16?
That's, Lordship, there is Friday. All right, Friday. 16, Lordship.
On the prayer made by Sri T. Tagum, Learned Standing Council, Education Department, matters are adjourned to be listed on 16/2.
Deeply obliged.
Is there any interim order?
No, my
No,
lord.
this is,
17 and 18, okay.
much of.
I make to mention item number 25, Lordship.
Yes, 25.
On instruction, Lordship, I may be allowed to withdraw this matter.
Your name?
K lawyer, Lordship.
Sri K. Lawyer. Who is for the other side?
T Tapak, Lordship.
Mr. T. Tapak? Is he around?
I have
Yeah.
already informed you. Lordship.
Sri K. Lawyer, Learned Counsel, submits that he has been instructed by his client to withdraw this writ petition. Full stop. Also heard Sri T. Tapak, Learned Counsel for the respondents. Full stop. Para. Petition accordingly stands withdrawn or stands dismissed on withdrawal. K. Lawyer, Learned Counsel for the petitioner. Okay.
Further,
Is there any interim order?
yes, Lordship, interim order.
Interim order passed earlier stands vacated.
Further, Lordship, I would to mention item number 26 and 27, Lordship.
26 and 27 years
This matter may be taken up after 2 weeks, Lordship.
for the petitioner.
Yes, Lordship. In item number 26, Lordship, I am for the petitioner, Lordship.
And have you informed the other side?
Yes, Lordship.
A prayer for adjournment has been made on behalf of the petitioners for the list after 2 weeks. 26, 27, same order, one common order.
Further, Lordship, I beg to mention item number 14, Lordship.
1/4.
Yes, Lordship.
Yeah.
This is a Lordship compensation matter, Lordship. And I have an instruction that the petitioner has received the compensation amount, Lordship. In view of that, Lordship, I may be allowed to withdraw this matter, Lordship.
Sri K. Lawyer, Learned Counsel for the petitioners submits that during the pendency of this writ petition, the relief sought for has been granted to the petitioner. Full stop. The said relief was pertaining to compensation for land acquisition. Full stop. Para. Also heard. Who is for the government? Sri Ram Learned State Council. Sri D. Kamduk.
Yes, madam.
Learned Standing Council Land Management. Full stop. Para. Writ petition accordingly stands dismissed on withdrawal.
Highly obliged.
Dismissed as there is no live cause of action. Withdrawal must be.
May I, your lordship? Your lordship, I beg to mention item number 20.
2-0.
Yes, your lordship. On behalf of Tony Parton,
Yes.
with the consent of the respondents. Your lordship, this matter may be fixed day after tomorrow.
Wednesday.
Yes, your
Mr.
lordship.
Kamduk, Wednesday, is it okay? Kamduk, where is it? Have you taken the consent?
Yes, your lordship.
On a prayer made on behalf of the petitioner, matter is adjourned to be listed on Wednesday date,
31st.
31st, 31/1. Okay.
Obliged, your lordship.
My lordship. Lordship, I beg to mention item number 22.
22.
Yes, ma'am.
Yes,
On behalf of CM Mantawan.
yes.
My lord, leading counsel is out of his station, my lord.
Okay, when do you want?
22, my lord.
After 2 weeks?
Yes, yes.
A prayer for adjournment has been made on behalf of Sri C.W. Montauk, Learned Counsel for the petitioners. List after 2 weeks. No interim order?
Yes, sir. My lord, interim order is there, my lord.
Para interim order passed earlier stands extended till the next date of listing.
Obliged, ma'am.
My lord, I beg to mention item number 29 to 33. Analogous matter on behalf of you, Dekasan.
Okay.
That this matter may be at least after 3 weeks.
Taken the consent of the other side.
Yes, sir. Yes, my lord, I have taken.
A prayer for adjournment has been made on behalf of Sri U. Deca, Learned Council. Full stop. List after,
3 weeks.
as prayed for, from a list after 3 weeks. At up till 33. Up till 33.
After 3 weeks.
29 to 33.
33, yes. 29, 30.
Yes.
My lord, I have to mention item number 24. I'm appearing on behalf of senior counsel, standing counsel. The matter has been sent for, affidavit has been sent for waiting. From like,
Okay. You, which department?
this for standing counsel for Guwahati High Court.
34.
24.
24.
Yes.
Okay.
We fix up the 2
Taken
weeks.
the consent of the other side. Have
No,
you
Your
taken the consent of the other side?
No, Your Honor. The matter has been sent for waiting. Affidavit.
Understood, but you have to take the consent. Before you make a prayer for adjournment, you have to take the consent. You make a prayer when the matter reaches, we'll adjourn the matter, but not now. Where is Mr. Who is appearing on the other side? D. Medhi? D. Medhi?
Lord, I am appearing.
Okay, he's seeking time.
My lord, they have sought time, more than 3 occasions, I think, my lord, to file their affidavits, my lord. It's a petty matter, my lord.
Okay, last opportunity we'll give.
It's a transfer matter, my lord. It's a petty case for the subordinate court staff from one place to another near his hometown because his brother died to take care of his parents. He just needs a transfer. Nothing else, my lord.
No, that is your projection. We do not know what is coming from their side. But if they have taken time for a number of occasions, we'll give a last chance. File it, we'll fix a date, his announcement council.
My lord.
A prayer for adjournment has been made on behalf of the respondents on the ground that the affidavit in opposition is at the stage of vetting. Sri D. Deca, Learned Counsel appearing for the petitioner, has submitted that adjournments were granted on previous occasions. Also, for Sapara, in the interest of justice, a last opportunity is granted to enable filing of the affidavit in opposition. Full stop. Fix on.
Can you take, my lord, as per your lordship's content?
Tell us.
Next Monday, my lord.
Next Monday. Monday they cannot file. Be reasonable. When can you come? Today is what? 29th.
29th.
We'll have it on 12th of February. Is it okay for you?
My lord.
12th February. But file it will not give you any chance. And why does the High Court need so much of time?
Because Your Honor, the respondent are from Changlang, they are posted at Changlang,
Are they required to come to give you instructions?
No, Your Honor, it takes time, Your Honor, from here.
Or you need to travel nowadays? Use the internet, use the telephone.
Yes, sir.
We will not have any special privilege for the High Court. You need to be, even you need to set an example, file in time. Why should you be given time?
Strict instruction was given to them to file their affidavits on 19th of December itself.
File.
Much so, like.
My lord, I am instructed the person with whom the record is, he has been replaced by another incumbent SE. So they have requested me to take some time. This may be fixed on 7th. Till then, we will not finalize the.
My lord, that order may be reflect, my lord.
We'll record
My
it.
lord, my lord, not to finalize.
Okay, heard Sri Tagum Learned Counsel for the petitioner. the petitioner has put to challenge the action of rejection of his bid by holding it to be technically non-responsive pursuant to an NIT for so and so, construction a full length, construction of full length. पूरा नाम लिखना है ना? Full stop. Apart from challenging the said decision, the acceptance of the technical bids of the private respondent number 8 has also been challenged.
My lord.
Full stop, para. So the G Tarak London Standing Council, RWD, however, submits that the incumbent who was dealing with the records has been changed recently, and accordingly, the records are to be collected from the new incumbent, and therefore some time will be required. Full stop. He, however, assures the court that no final decision would be taken in the matter till the next date fixed. Full stop, para.
7th.
As requested, list on 7/2/2023.
Publish.
2024.
2021.
Deeply applied.
My pleasure. This is the matter, my lord. On the last occasion, my lord, the instruction has been is required to be published by the my lord, the counsel for the petitioner, also my lord, respondent, state respondent, my lord. My lord, as per the updated, my lord, the portal, updated in the portal, my lord, website, my lord, till date, my lord, the finalization of the financial bill has not been uploaded, madam.
No, they, according to them, you do not meet the yearly turnover
Correct,
requirement,
madam.
which you say is an erroneous decision. You
My lord,
meet otherwise. What
agree.
is
Yes,
it?
I have received the instruction, Lordship.
What does it say?
Lordship, before coming to this instruction, kindly see the Lordship RFP Lordship, the NIT Lordship. Where Lordship, the requirement of this turnover is given, Lordship. Kindly come to page 35, Lordship.
3/5.
Lordship. It starts from page 31, Lordship. I'm taking Lordship to the page 35, Lordship.
Yes, please.
Page 35 at 1.7.4, Lordship.
One 1.7.4.
4, Lordship. Financial soundness, Lordship.
Yes.
This is turnover, Lordship. The clause on Lordship.
Yes.
The buyer should have an average annual financial turnover gross of not less than rupees 158.50 crore on any works contract during the last 5 years. Balance sheet duly audited by chartered accountant. Lordship. What it says, Lordship, the average annual financial turnover, Lordship. The average must be not less than 158.50 Lordship crore. Now, kindly come to Lordship.
Yes.
For 5 years, Lordship, each year, Lordship, average has to be taken out, and average must not below the 158.50. This is the Lordship condition, Lordship. Then kindly come to page 121, Lordship.
Yes.
121 is the Lordship financial information. The
121.
121, Lordship. This financial information is under Form A by the petitioner, Lordship.
Yes.
Here, Lordship will find the petitioner has given financial turnover for 5 years, Lordship. The first one is 158, then one is 112, then 99, then 11, then 11, Lordship. When all these are added, Lordship, and then average is taken out, Lordship, it comes to Lordship 120 only, Lordship. How, Lordship? They kindly come to the instruction which I have received, Lordship. This is the information furnished by the lordship, petitioner lordship. The financial turnover for 5 years. Out of the pace also lordship. The first one is 158 lordship. Rest are lordship below the 120 lordship.
No. Second is much more.
Lordship.
Second is much more.
This is in
11222.
lordship.
Okay. 11222. Okay, it's less.
Less only 11 lordship.
11.
No.
112.
11, madam.
The total gross is given in down below lordship.
100
Plus
madam.
1 lordship.
What is total gross turnover from last 5 years? 60.
60.
How do you explain this?
Then,
Madam, as per
then
the
kindly
plan-
come to the
No,
instruction.
no, have you challenged that particular requirement of 1.7.4? You have not challenged.
No,
No,
not challenge.
You said that you have
Fulfilled.
you fulfilled this
Fulfilled, madam.
requirement. This the CA information at page 127 does not seem so.
127, madam.
So what Mr. Tapin has just
Is,
Rest of
madam, he is
record.
referring 121, madam.
1 to 1 at annexure 4. Yes,
Annexure 4, madam.
Yes,
Which is
121.
my financial turnover, madam.
Yes. You need to have 158.50
Madam.
annual average turnover for the last 5 years. Every year, your average annual turnover has to be 158.50 at least.
Correct.
Here, for 22-23, it's 158.84. No problem. Isn't it? But
Madam-
2021-22? It's 112. Then next is 99. And 117.
Here lordship, even if one is 99 lordship, race goes beyond the 100 lordship, and if all are plus and then average is taken out and it reaches to 158, then it's okay lordship.
Then also it doesn't.
It also doesn't matter. And even lordship, the technical evaluation sheet I have produced lordship, they are also the technical evaluating committee has lordship.
Professor, it does not appear to be erroneous this time.
Malad, I'll just explain to that, Malad, I'll satisfy your lordship how, Malad, this has to be calculated, Malad. Malad, the plain reading of the, Malad, the terms and conditions, Malad, the lordship has already seen.
Yes.
Again, I'll come to, Malad, page number 35, Malad.
Yes.
May I read again, Malad?
Yes.
The financial soundness, Malad. The bidder should have had average annual financial turnover, Malad. Annual, Malad, turnover, Malad. Annual, when annual speaks, Malad, it is for a particular year, Malad.
Yes.
And the financial turnover of the gross of, Malad, not less than 158.50 crores. Only on
any works.
Any works contract during the last available 5 years, balance sheet duly audited by the chartered accountant, Malad. Malad, what does it mean, Malad? To my Malad humble understanding is only for a Malad, the one Malad contract work, any contract work on any contract work, if it meets Malad not less than 150 crores, then Malad, the financial turnover is meet up.
So what is the meaning of average?
Average, Malad, the average, Malad, the average, how this average is Malad used. It is no meaning, Malad.
No, we cannot introduce new meaning.
Malad,
you have to read whatever the
Malad,
clause is.
if
Clause
it is
says average annual turnover of not less than so and so on any works.
Exactly,
Not
Malad.
work, not one work.
Malad, my
If
explanation.
it is one work, it cannot be an average.
Malad, my explanation is it has to be Malad average Malad in a Malad work in a year. Sorry, Malad, in annual work annually, Malad. If 5 works, 6 works, 7 works is given, Malad, then average will be counted, calculated, Malad.
Okay. And if
it is
Then
work.
rest,
Rest, my lord, admittedly, rest is not, my lord, meet up. Any contract work, my lord.
you say that if you meet the requirement even for 1 year.
My lord, as per the language, my lord.
Sorry.
My lord, it is as
No,
per
we'll
the-
admit this, but there's no interim order. Heard.
and my lord, and apart from that, my lord, the other, my lord, there are, my lord, technically they are not responsive. The other respondents, private respondent here in my lord, they have been, my lord, considered.
At the
There,
instance of a non-responsive person, we are not going to examine the deeds of others. First, you need to show your eligibility.
my lord, as my lord, contention is, my lord, I'm meet up, my lord, this condition.
We'll record your submission. Third, Sri M. Kato, learned counsel for the petitioner, who has put to challenge the action of the respondent authorities in holding the bid of the petitioner to be technically non-responsive. Full stop. It is the case of the petitioner that an RFP was floated on 16/10/2023 for the so and so name of the worker. It was also written in the earlier order. Full stop. It is submitted that one of the requirements was with regard to the financial soundness as given in clause 1.7.4.
One again, my lord.
As per the said clause, comma, a bidder should have average annual financial turnover within bracket gross of not less than rupees 158.50 crore on any works contract during the last available 5 years balance sheets duly audited by the chartered accountant. Full stop. By drawing the attention of this court to the financial information given in form capital A within bracket annexure 4, comma, the learned counsel submits that for the year 2022-23, comma, admittedly, the figure is 15884.13 lakhs. This is lakhs, I think.
Lakhs. My lord.
Which is more than the minimum requirement. Full stop. It is contended that the meaning which is to be assigned to the requirement of clause 1.7.4 is to have met the minimum amount thought to be given on behalf of the petitioner. He is prima facie not tenable, as the expression used is during and not in any one of the last 5 years. Full stop. He has also submitted that it is the average annual financial turnover for the last 5 years which is required. And in any case, comma, the settled position of law is that the interpretation of the author in a contract document is to be construed as the best interpretation. It's the para. Be that as it may, comma, let notice be issued returnable by 6 weeks. 3, as in the learned senior government advocate accepts notice on behalf of respondent numbers
1 to 6 laws.
1 to 6. Let extra copies of the petition be served upon him.
My lord. My lord, we have already served the copy.
Extra copies.
Extra copies we have already last occasion, my lord.
Oh.
Only two copies.
2 extra copies.
Okay,
My lord.
let extra copies of the petition be served upon him by tomorrow. Steps for service of notice upon the respondent number 7, 8, 9, and 10 be taken by registered posted AD. Steps within 2 days. Full stop. This heard on the interim prayer, comma, a full stop para. This court is of the prior opinion that the interpretation sought to be given on behalf of the petitioner may not be legally tenable, full stop. Be that as it may, comma, it is observed that all action taken pursuant to the RFP in question would be subject to the outcome of this writ petition.
Deeply obliged.
Yes, Kapil, Upal, who also places on record the written instructions obtained by him.
The earlier interim is still modified.
Where there is an interim order over.
Earlier it was.
Fine. No, we have already rejected. There is no, it is further made clear that the interim of, made clear that the observation made by this court on 24/1/2024 that no final order of allotment be passed accordingly stands modified.
Modified lawsuit. And on this same ground lawsuit, not only the petitioner lawsuit, another 4 lawsuit bidders have been already rejected on the same ground lawsuit, turnover lawsuit.
Okay.
Applying the same principle.
Three, Kapil further submits that that applying the same clause, comma,
Lawsuit.
the bids of 4 other bidders have been rejected and there is no malafide in the impugned.
My lord, I'll come with the additional affidavit, my lord, that my lord, work has already been executed by them, my lord. I have the photographs, my lord.
Notification which is on page 29, under which this acquisition has been done. Page 29, your lordship.
Yes.
Yeah. I start reading, your lordship.
Yes, yes. What is your grievance actually?
Our grievance, your lordship, is that our property is being taken over and no process has been followed. No compensation has been given, no notice has been given. We have not been heard. And on top of that.
Yes, yes, what do you say? How can you acquire land without following the due process?
No, my lord, there has been procedures, my lord, followed, my lord. Boards have been constituted to identify the affected people, my lord. Moreover, in this writ petition, they are claiming compensation in the reserve forest. As per page 29, the notification, even under a reserve forest, the government has taken a policy decision to pay compensation. If petitioners...
Are you contending that this land is not their land? It's a reserve forest.
Reserve forest, my lord.
Lordship, if I may be allowed the indulgence of showing you just 3 or 4 documents which together tell a story. What they have done, your lordship, just to rebut my learned friend, is that they have denied me rights by one notification and then brought in ad hoc rights for non-existent people, that is people who have no rights. If your lordship allows me some indulgence, I will just go through it. These 4 documents, let me show your lordship, and your lordship will have the clarity that is needed. So, your lordship, this notification of 31st August 2023.
Yes.
It says, I read the short title in para 1. Spatial ex gratia relief package towards right of way for 132 kilovolt transmission lines passing through reserved forests under the comprehensive scheme for strengthening transmission and distribution system of Arunachal Pradesh 2023. Para 2. Right of way 132 kilovolt transmission line, and they here point out that the amount payable for, I read para A, your lordship, for the tribal population as identified in para 3 of this policy, and now they deny me, who are not entitled for any benefits including compensation of specific nature, resettlement or rehabilitation benefits, and ex gratia payment amount, and this is 50% of what would be due had I been entitled. I don't want to comment on this as yet, your lordship. Let me complete the 4 documents, then I'll paint the picture. It would be self-evident actually. Now, para B, your lordship, it talks of the proposal bearing calculated cost will be submitted to Ministry of Power, Government of India for implementing agency. Your lordship, an ex gratia payment payable to people who are not entitled to any payment cannot be claimed from central government. I'm just bringing it to your lordship's attention.
No, it is their headache. Well, how they-
That's why I'm just bringing it to your attention. I'm not pressing this point. Then C says this will not serve as precedent for any other.
Okay.
Now, your lordship, come to page 30A, which is the next page.
Page 30.
Page 30A, your lordship.
Yes, yes,
Now, this is a notification of 29th August 2019.
yes.
This notification, your lordship, lays down clearly the mechanism to be followed for compensation for transmission lines.
Okay.
It also lays down on page 31 the width of right of way, and it also talks of the percentages which shall be due, 15% and 85%.
Okay.
Right, your lordship?
Mhm.
Now, I read para 1, last section. Payment methodology of compensation toward damages stipulated section 67, 68 Electricity Act 2003, read with section 10 of Indian Telegraph shall be in addition to compensation toward normal crop and tree damage. Amount will be payable for, and the amount is mentioned. Now, your lordship, I take you to document on page 65. Page 65, your lordship. Page 65, your lordship. This is extract of cabinet proceedings, the minutes of the meeting.
Yes.
Page 65. I read, your lordship. Para 3B. This is regarding
No precedent. DB.
para
Proposal.
3B, proposal for right of way in reserved forest lands.
Okay.
Now, here it talks of for the tribal population occupying reserved forest lands coming under specifically granted right of way under the right of way of comprehensive scheme for strengthening the name of the, who are not entitled for any benefits,
Yes.
including compensation specific. Now, your lordship, I take you to para 4 of the same minutes. Para 4 on the next page, page 66.
Yes.
Now, your lordship, this I read, for identification of beneficiaries and assets thereof, a board of officers is constituted by the concerned DC in matters related to land acquisition. This is the correct position, your lordship. This is how it should be. In respect of ROW, guidelines issued by the Department of Power for identification of beneficiaries in non-forest areas with specific requirements for identification of beneficiaries in reserved forest RF areas, having notified tribal rights as per FRA Act. This is the 2006 Act, your lordship. Para 3 is in direct contravention of what is provided in para 4. Para 3 talks of rights. Your lordship, I want to bring to your attention that the Telegraph Act and the
Indian
other act that is mentioned are previous to the crystallization of residents inside forests as per the 2006 Act. These acts precede. So those acts do not provide, but the 2006 Act very clearly provides for rights of people. And if your lordship, when I take
Where
your
is the 2006 Act?
2006 Act, your lordship, is the, I'll just, I made a small compilation, your lordship, which has the, lordship, this is the manual for this thing, for land acquisition, and the 2013 Act itself.
This per se is not an acquisition.
Pardon, your lordship?
This per se is not an acquisition.
Lordship, there is an acquisition also involved. Lordship, there are two things involved here.
No, for right of way, there is no
No,
acquisition.
for right of way, there is no acquisition, but for the towers, there is acquisition. So there is a total of some 12 hectares or something acquisition involved in different plots. So if my plot is here, if the tower area, some square meters, That is an acquisition, your lordship. And the right of way is just a duration of the ability of the land, for which 15% is earmarked as per law of the prescribed rate. Here, an arbitrary legal fiction has been created of people who have no rights. Your lordship, people who have no rights can be given grants.
What is the 2006 Act? Which one?
Your lordship, 2006 Act, I'll take you, I just handed over the document to your lordship. If you see, your lordship, the Right to Fair Compensation 2013 Act,
Yes.
this itself specifies page 24, your lordship, of this compilation. I've given page 24 of this. This is selected papers from pages from the
You have not marked the pages. Which one?
lordship, page 23, just next to 23, your lordship. Next to 23. 23 on right hand corner, lower right hand corner. You'll see 23. This is the fourth or fifth page, your lordship.
Yes, what is this?
So this page, your lordship, is from the Right to Fair Compensation and Transparency Act of 2013.
Yes.
Now this in clause 3, which is on page 24,
Yeah.
internal page 3.
Yes.
Your lordship, it says in clause 3, subclause 3, it says the scheduled tribes and other traditional forest dwellers who have lost any of their forest rights recognized under the scheduled tribes and other traditional forest dwellers recognition of forest rights act due to acquisition of land. Your lordship, it further here itself, again, on
This has to be read in context with acquisition of land.
that's true, your
And
lordship. There are
the-
two things happening, your lordship. Land acquisition is also happening and right of
Where is
fair.
the acquisition?
The amount of land which is being, your lordship, I'll show you how much acquisition is there. If your lordship comes to
Is it
page,
called an acquisition?
yes, your lordship, I'll show. It's from their own documents, I'll show. If your lordship allows me to go
No,
sequentially, your lordship
show
become
us the
clear.
acquisition part.
Lordship, I'll show you.
Unless it is for power station or something
Lordship,
of that
it
sort.
is very clearly
For
acquisition is also.
power, I don't think it's acquisition.
Lordship,
It
I'll,
comes under ROW.
lordship, kindly see page 71.
7-1
7-1, your
of
lordship,
your petition.
of the writ petition, your
Yes.
lordship. Now, this is a FRA certificate.
Yes.
FRA certificate is needed only when acquisition is done. And I'm pointing out to para A. The complete process for identifying settlement of rights under FRA has been carried out for the entire 119 hectares of forest land. Area of diversion. Diversion means acquisition, your lordship, for some other purpose, public purpose here.
Diversion means acquisition.
Yes, your lordship. Your lordship, I could take you to the Land Act itself.
Yes, please.
So the word diversion has been used. The implication is clearly acquisition, your lordship, of diversion. I'm just looking for. See, the normal usage is forest usage, which does not allow any other usage except wildlife plantation, the wild growth of trees, etc. And when it is diverted, and the government diverts it by acquiring it. Here it is being diverted for the purpose.
Here a line is being transmission line is being.
Lordship, I humbly submit, transmission line does not amount to acquisition. There is no acquisition involved. But when you put the feet
Okay,
on the
now,
ground.
today you're moving for the first time.
Yes, your lordship.
Will seek the response?
Your lordship, may I humbly submit, as there is urgency involved, status quo may be maintained till next date when I may be allowed to press for press for stay at that
Notification
date.
of August 2023.
Lordship, yes.
Notification of August 2023.
Your lordship, they have moved rapidly during this time.
6 months you take to come.
No, lordship, we came to know, lordship, this hasn't been publicized. We came to know only in December when they were putting feet down in our land.
So that notification we cannot state, sorry.
I'm not asking for a stay, Your Lordship.
Status quo is a stay. What is the meaning of a status quo?
So, Your Lordship, at least I may be allowed to argue on that date on stay. On the issue of stay. That's all I am asking, Your Lordship. Otherwise, Your Lordship, may I humbly submit my problem?
That will not be a proper observation. After 6 months, how can you argue on a state?
No, Lordship.
You we'll ask them to file their pleadings and have it for disposal at the admission stage.
Lordship, I would be very happy with that.
We'll do
But
that.
my experience is that.
We'll do that. We'll do that. Your
Lordship, just, okay.
Mr.
Yes, ma'am.
Ratan,
Yes, madam.
you file your response.
Yes, madam.
And give me
Who's
2
appearing?
weeks.
I appear for
Mr. Kamdak for?
one, two,
Respondent of 4 laws.
1, 2, 3.
Your Kashyap,
Yes, Your Lordship.
heard three Kashyap learned concept for the petitioners who, by means of this petition, petitioners, full stop, the petitioners who are 5 in numbers have put to challenge a notification dated 29, no, what is the date? 31/8/2023. Issued
Lordship,
issued by the Commissioner, Department of Power, Arunachal Pradesh, and also made and are also seeking certain other reliefs. Full stop. It is submitted that there are inherent defects in the impure notification by which the petitioners are likely to be deprived of their legitimate rights. Full stop.
Lordship, may I seek your indulgence? If you see the writ petition, Your Lordship, just on the page, 3rd page,
Yes.
I am referring in list of dates to item number 10. I'm just trying to point out, Lordship, we are not
Item
late.
number?
Item number 10, Your Lordship, serial number 10.
Yes.
That is 18/12/2023. That is the DC collector, Pake Kasang district has issued final joint verification recommendation board which was constituted for this. And Your Lordship, after that, it is very recently when people came into our fields that we have immediately.
The Learned Council has also referred to a notice dated 18/12/2023 issued by the DC cum district collector, Pake Kasang district, whereby a joint verification and recommendation whereby a board for final joint verification and recommendation has been constituted. Full stop. It is submitted that immediately on coming to know about the said notification, followed by one dated 21/12/2023 by the circle officer, that the present petition has been filed. Full stop. Let notice be issued returnable on. Yes.
2 weeks, madam.
Yeah.
So-
Have a date of your convenience.
Lordship, I'll try to come on whatever date is given because this is urgent matter. Like you,
Since you are session.
Lordship, give me 2 weeks for rejoinder simultaneously.
Okay, returnable
But this should
by
be.
returnable on 21st of February. Full stop. Sri Ratan, the learned AAG, accepts notice on behalf of all the respondents.
1, 2, 5, and 7.
1, 2, 5, and 7, whereas who's Mr. Kamdak?
Kamdak for, what's his respondent number 4.
4.
Respondent number 4.
Yes.
And Mr. Parme for?
3.
And
There
Parme
is-
for respondent number 3. Let extra
Respondent
copy-
number 6, notice has to go.
let extra copies of the petition be served upon the learned counsel for the counsel for the respondents appearing. Full stop. Steps for service of notice upon the respondent number 6 be issued by registered post with AD. Where is the address here of this respondent number 6? This will not be enough, I think.
Itanagar, Your Lordship.
Itanagar is too vague.
We'll put the postal address. Your
Yes,
Lordship.
yes. I
Your
think
Lordship, simultaneously, there are some other minor errors here because some 2 pages have been repeated. We may be allowed to correct those with the
no,
clerk.
those without an IA, it is difficult nowadays because of the CIS system. We'll ignore it. if
Okay.
those,
Your
does
Lordship.
not make
But
any-
they are very obvious. These
Okay,
2
okay,
pages have
doesn't-
come in together.
Doesn't matter. Doesn't matter.
May-
Doesn't
Your
matter.
Lordship. Was my job to bring it to your attention.
Registered post with AD, yeah? Steps within 2 days. Full stop. Since urgency has been expressed on behalf of the petitioner, comma, it is expected that before the next date fixed, comma, the pleadings would be exchanged. Full stop. This court will also
Yeah.
consider taking up the entire matter for final disposal at the admission
Much
stage,
obliged, Your Lordship. Much obliged.
if found convenient.
Much obliged.
Extra copies.
We have already said.
Obliged.
If you can hand over.
Lordship, one small
This you
submission.
can hand over next.
Yeah, naturally. Your Lordship, one small submission.
Please.
Could you make it a fixed date?
Where said?
Oh,
19th of.
no, what I meant is fixed date, maybe in the afternoon or something. Others, what happened? And I go back a lot.
19th, you make a mention, will
19th afternoon, first after lunch, it may be taken. on.
difficult. I think there may be motion matters. Make a mention before the court.
Okay, much obliged.
19th, perhaps the 19th. 19th. What did it? Oh, sorry, we have said 21st, not 19th. 21st.
21st.
Yes, next. MTS.
Yes, Lordship. Termination, Lordship.
My lord, same matter, my lord.
Lordship.
Have you filed, typed any matter
Yes,
before?
Lordship.
No.
Lordship.
MTS?
Item 4 to 12.
4
Lordship.
to
All
12, my lord.
MTS.
Yes,
All.
Lordship, here,
Teacher.
Lordship, item number 4 and 5, Lordship, here the petitioners are TGT, trained graduate teachers.
4 and 5, TGT. Huh?
And from 6 to 12, PRT, primary teachers.
Oh, not MTS.
Yes, Lordship.
4 and 5 are trained
TGT.
graduate teachers.
Yes, Lordship.
And
6 to 12,
are
primary teacher, PRT.
teachers, huh? Heard. Sri Jeevam, learned counsel for the petitioner, who by means of this petition has put to challenge an order of termination of service dated 16/11/2023. Full stop. Termination of service, the petitioner was appointed as in first two items, it will be TGT, and here with primary teacher for full. Para, Sri Tagum Tulana, Standing Council Education Department, however, submits that the initial appointment itself was not done by following the due process of law. Let notice be issued, returnable by 4 weeks.
May I, Lordship? Lordship, here, Lordship, item number termination order is impugn order termination is same, Lordship, in item number 4 and 5. But other are different, Lordships.
What dates?
Dates, Lordships, that 26 2020.
Give a list.
Okay, Lordship.
Item numbers, termination dates, okay. In 4 and 5, it is the same. Sri Tagum, the learned standing counsel, accept notice on behalf of all the respondents that extra copies of the petition be served upon him within 2 days. List along with
the other read petition.
Where number?
My lord, just I'll furnish, my lord.
Give it to her. Okay. Termination order date will be different In 4 and 5, it's this date, and 6, 7, 8, 9 onwards. It first will be primary teacher, and dates are also different.
My lord,
4 and 5, it is TGT, and date is same. Yes.
my lord, at number 7 is TGT, my lord.
7 is TGT.
TGT, my lord.
7, yes, Mr. Bam.
Again, yes, it's TGT, my lord.
Yeah, sorry, Lordship. Some mistake.
7 is also TGT, okay? Standing council is more aware of the facts.
Yes, Lordship.
Why? You were busy last night.
No, Lordship.
You seem to be busy. You are very tired. Sunday evening party. Extended party.
Yes, Lordship.
Okay.
TGT, Lordship. Yes, Lordship.
TGT, okay. Yes, madam. Nangan, what is this?
My pleasure, Lordship. My lord, acquisition was done, and they have not paid me the interest as well as yes, not solution, the interest which is the possession prior to the prior to the award, that they have not paid. Also, they have not paid the rent for the rent and damages for the past uses. The case was initially they have filed an affidavit.
It was acquired for whom?
The Ministry of Defense. Oh, sorry, the Ministry of Defense for the Ministry of Defense.
Okay. It was acquired for you. You are the paying authority. Yes. Why haven't you paid?
We have already paid the amount is calculated by the.
No, my lord.
Yes, you have paid the entire amount.
My lord, as per our affidavit, it is very much
You
clear.
tell us one thing, the amount which you have paid to the state government, is it the amount which the petitioners are claiming, or is the petitioners claiming something else?
Something else, ma'am. The amount, my lord, ascertained by the district administration is already been paid, my lord.
Yes, my lord.
Yes, district administration.
My lord, in this case, my lord, they are asking, my lord, delay in payment interest, my lord, as per that Lara Act 2013. Then also, my lord, in higher rate side, my lord.
Higher?
Rate side, my lord. Rate.
For
Which-
that, then there is a reference, they can go for reference.
Yes, they can go for reference, my lord.
But
No.
interest part? Interest isn't.
No,
it
we are not
permitted?
claiming higher rent, lordship.
But
We are not
interest
claiming
part,
that.
my lord.
The act envisages payment of interest, isn't it?
Yes, in cases of in urgent when the land is acquired, invoking the urgency clause, then the possession which is prior to the award, that part has to be paid. That they have not paid. Of course, although in this case,
It is akin to 17 of the earlier
yes,
act.
yes, exactly akin to that. Your lordship knows very well in RL Jain case what was said with regard to that lordship. Now, the collector has also to ascertain.
You have filed your pleadings otherwise.
My lord, we have received the comments from the deputy commissioner.
Now, if you think that from the comments you are in a position to argue, then you'll fix for admission, hearing and disposal.
Yes, my lord, it can be done. Because they have,
You have filed the pleadings.
Yes, ma'am, we have filed.
ultimately, my lord, the central government, they have to release everything, my
No,
lord.
no. Central government will release, provided you come to a conclusion, or we come to a conclusion, that their claim is legitimate.
My lord.
You have made the calculations. The central government has nothing to say. Whatever calculations you have made, it is admitted that they have paid.
My lord.
They are agreed that the calculation itself is not properly done. So the ball is in your court now. If you can satisfy that the calculation is properly done, then they may not have a case.
My lord,
But
calculation was done. They have accepted amount, but with resistance, my lord. They said we are not satisfied with this. It's reflected in the communication made to the ministry also, my lord. With objection, they have received the amount, my lord.
With objection, then
Yes.
they have the right to.
Yes, yes.
Is
So that part, my lord, neither we can deny nor the central government. It's a part of record, my
No,
lord.
that is what we are, and even by their acceptance, they
My
are
lord.
not diminish their right or extinguish their right to hesitate. It is good that you have claimed on you have accepted on protest.
Yes.
Heard, Miss, and then let it counsel for the petition, one petitioner.
No, Lordship. Record petitioners, sir.
Ajit Sarkar.
33.
Huh?
33 petitioners, Lordship.
What is the name of the case?
Punso member,
Ajit Sarkar.
33 petitioners.
Yes.
Yeah, Timala, why?
Huh? Rajiv Sarkar. Who is Rajiv Sarkar? Who is this Rajiv? Oh, wrong record has come. Yours is 97 of 2021. We have
Yes,
the records
Lordship.
of 97 of 2022.
Oh. In any case, Lordship, since they
No,
are
we cannot pass the order without the records.
tomorrow, then Lordship, because day after tomorrow I'll be out of station.
We don't mind taking even today, but records have to be there.
Yes.
Have some records of 2022, same number.
Oh.
He was lucky as well as unlucky. Records are before the court, we cannot pass orders. And your clients are unlucky. You are there, we cannot pass the order.
Lucky but unlucky.
Unlucky. Luckily unlucky.
Luckily unlucky. So when you are tomorrow? Better tomorrow? Tomorrow.
It appears that a wrong record has been placed. So while the listed case is WPC 97 of 2022, the records of WPC 97 of 20, and while the listed case is WPC 97 of 2021, the records of WPC 97 of 2022 has been placed before this court. First of para, raised to this the case again tomorrow with the proper records.
All right.
यार मुझे खबर है तुम तो नंबर मिला बोला
My lord, the issue pertains to
Just a minute, madam. Just a minute. It will be replaced. It was item 28. I think 28, item 28 of today's list was also 97 of 2022. So records might have been interchanged.
Item number 19, madam.
No, 20. No, after 38. Yes, it's there. Number put there.
20 is different, madam. It's
Understood. 28, the number is the same, 97. Records of 97 is always this there. We can pass order. Don't write the earlier order. Heard Miss N. Rangan, learned counsel for the petitioners. Full stop. Also heard the M. Kato, learned deputy SGI, who has filed the affidavit in opposition. Whereas the state is represented by Sri R.H. Napam, the learned AAG, who submits that the instructions have been received. Full stop para. As agreed to by the parties, list for admission hearing when?
Tomorrow, Lordship.
Tomorrow.
Any date, my lord, I don't have it.
After 2 weeks, Lordship.
Next week. Next Tuesday.
Lordship,
Is it okay?
Tuesdays, I think a holiday.
Next Tuesday is a holiday. 6th is a holiday, okay. Or on 8th? On 8th, is it 8th Thursday? 8th, 8 to.
Oblige.
Wrong record, wala mat likh na.
This matter can be disposed of.
Explain why?
Well, the matter pertains to establishment of BKV in Tawang, Lungla. Then certain issues were there that land were not acquired. And then although there was a Gram Sabha meeting, then signatures were not put and all those claims and counter claims were there. But my lord, I'll take only 2 documents where my lord can close this case, my lord. Kindly come to, there was,
Minutes of meeting of 13th of July, I think
this has been disputed, my lord. So I'm not onto that, my lord. Kindly come to page 84 straight of my read petition, my lord.
84.
Yes.
Yes.
84.
Yes.
But there, what had happened is in annexure page, but for this for the moment, there is another page in the affidavit in opposition which I have cross-checked with the records by the state, my lord. Page 84 for a moment, my lord.
84, where in 84?
80, my lord. 80 of
80.
affidavit in opposition by the state respondent, my lord. All my, my lord, grievances were referred to the additional deputy commissioner has relegated us to the Gamburas, my lord, to take a call on this, my lord. My lord will kindly come.
Page 80.
Page 80, my lord.
19th of May.
Yes, my lord. 1, 2, 3, 4, 5, my lord, para 5, my lord. As the NOC for the establishment of BKV at Solase, Lungla, and the land donation for establishment for BKV Lungla was submitted and executed by respective GVs. Sri Pandan Sring and the co-signatories are advised to approach their respective GVs for withdrawal of their consent for donation of land for establishment of BKV at Lungla. Pursuant to this, my lord, then we have submitted the representation at page 84 in my read petition. Gamburas. My lord,
So 84 of your read petition.
my read petition. Taking on board, my lord, the Gamburas now they are also the lowest civil court judge now. They can, without impleading them, my lord, can be directed to take a call on this, my lord.
Yes. Heard Sri T.T. Tarak, learned counsel for the petitioners. Also heard Sri N. Ratan, learned AAG, Arunachal Pradesh, for the state respondents. Who else?
My respondent number 7.
7, Monto.
HP Jammu.
Oh, sorry, HP Jammu for
Respondent number 7.
learned counsel for respondent number 7.
I got 8 to 15.
Name?
Newly implemented.
For respondent number 8 to 15. 115, yes, 15. Full stop. Mera. Considering the subject matter, comma.
My lord, I am for respondent number 5.
What is your name?
T. Omo. T. Omo.
T. Omo, for respondent number 5. BKV.
Yes, BKV.
My lord, I am for respondent number 1. Okay, Kamruk for respondent number 1 and 2. Land management. As considering the subject matter, comma, the developments which had taken place and as consented and as agreed to upon by the learned counsel for the parties, comma, the instant writ petition is taken up for disposal at the admission stage. Full stop. Para. The petitioners who are $19 in number have approached this court challenging an NOC dated challenging the willingness oblique NOC dated 16/9/2021 and 18/9/2021 with regard to acquisition of community land of the petitioner under the Fair Compensation Act. Which act?
Yes, 2013,
Under the Right to Fair Compensation Act. 2013. Full stop. Para Sri Tara, the learned counsel for the petitioners, by referring to a communication dated 19/5/2023, which has been brought on records by the affidavit in opposition filed by the respondents 3 and 4, has submitted that the petitioners could approach their respective Gaon Buddhas within bracket GB small s with regard to the grievance relating to withdrawal of their consent for donation of the land. Full stop. In terms of the said communication, the petitioners had submitted an application dated 30/5/2023 to the respective Gaon Buddhas for withdrawal of their consent. Full stop. This court has been informed that the matter is under active consideration, and the Gaon Buddhas are also vested with powers to deal with such matters. Full stop. Para. In view of the aforesaid development, this court is of the view that there is no requirement to keep this writ petition pending any further. Full stop. Para. Accordingly, the writ petition is closed by directing the concerned Gaon Buddhas to consider the representations of the petitioner and pass appropriate orders strictly in accordance with law. It is however observed that the petitioners, that the parties would have liberty to hesitate the outcome of such consideration if so advised.
But that Gaon Buddhas may be directed to dispose of the matter within a period of 15 days or 1 month.
They are not before this court, not
Yeah,
proper.
correct.
Such disposal may be made expeditious.
Experience. Great.
Status quo order dated 26/6/20.
Status quo merged.
The order of status quo dated 26/6/2023 accordingly stands vacated.
Obliged. My lord, this is beat a case, my lord, a small form of tender. My lord has made an observation this morning in one particular tender case, wherein my lord have observed that it is author of the tender are the best to interpret the tender documents and terms and conditions. Here is a case, my lord, what happens is the terms and condition provides itself that you need not, you have to produce or submit the original copy of the affidavit at the time of opening of the tender. Accordingly, the petitioner is a reputed class 4 contractor and presented the paper on the day of opening of the tender. The horse that, my lord, I have been rejected. My lord. That is my case. Sum and substance. I placed it the document.
But have they admitted that you had given the affidavit
No,
on the day?
no, my lord. They say that you must comply with the terms and conditions, and annex of the tender document is a must, according to them. But this stand of the government is authorized to what is provided in the terms and conditions.
Let us see the terms.
Yes. My lord, kindly come to page 35 straight.
25.
25.
Yes.
Special terms and conditions, my lord. I would indulge my lord only to three conditions, 5, 11, and 9, my lord.
Yes,
5 we read, my lord.
yes, please.
The firm must enclose original copy of bank solvency or financial soundness certificate in support of his financial background to complete the project, even on the eventuality of unavoidable delay in payment owing to such reasons as financial crunch of the client.
Come to the clause, consent clause.
Consent
5,
clause.
5 or 11.
Yes. Also interpolate anything, or nor they can give any extraordinary literal meaning to it, my lord.
Yes.
The line itself is very clear.
Yes.
I fulfilled it, my lord. And they have arbitrarily rejected my tender documents, my lord.
They talk about the original papers. Otherwise, you need to give the copies of those papers along with your bid.
We have submitted, my lord.
Oh, that is your case then?
Yeah, we have submitted the bid.
Because this latest GST for the past proceeding should be enclosed in the technical bid. These are all papers which you need to enclose in your bid.
Correct.
And only the origin you
Correct.
need to give for verification. That is
Correct.
the normal process.
That's we
Is
annex
it your case that you had annexed everything?
we annex everything, my lord.
And at the time of opening, you have also given the original. Not
Original.
accepted.
Yes.
Yes. Mr.
My lord, there is one
Come on.
thing. My lord, their reply, the executive engineers have appreciated me. Kindly come to page 35 for a moment, my lord.
35
35
of your repetition.
of my repetition.
Yes, please.
My lord, I read from para 2. In this regard, this is to clarify that the serial number 11 of special terms and conditions states that the firm should submit the following documents in original at the time of opening
What
tender.
is your name? Ninur.
Yes, my lord, Ninur.
Okay.
In this regard, this is to clarify that the serial number 11 of special terms and conditions states that the firm should submit the following documents in original at the time of opening tender. He also reiterates that. Where the indicated documents are namely GST registration certificate, 2 PAN card, 3 PRC for ST, 5 firm registration, staff detail, technical, so and so, proof as per entitlement of class of contractor. 8 IT returns, your tender for the mentioning.
First, let us see your rejection.
Rejection is next page, my lord. There is nothing, my lord. 36. No remark, nothing, my lord.
Where?
My name is not there.
These are what?
These are awarded to those
Name of
firms.
successful bidders.
Yes.
Where is your rejection? No rejection.
No rejection. This letter speaks, my lord.
Okay, this is your letter.
Yes.
36 are the list of
Yes, my lord.
list of eligible
Yes.
bidders.
Yes, yes.
Bidders.
My lord, para 3 I read.
30, 35 reasons. Okay, please read.
This is also to clarify. No, my lord.
Yes.
This second para I will read again.
Yes, it was not rejected on the basis of non-fulfillment of the very condition.
Yes, ma'am. Kindly, they admitted it. That is not the ground that my tender has been rejected. This is also to clarify that whenever an affidavit is required to be submitted, it needs to be submitted mandatorily in original, never it in photocopies unless specified otherwise. Madam, this is the brain they have struck, where we have stopped thinking. They started thinking from there, madam. That is nothing but contrary to the clause 11. You are asking us to produce the original affidavit on the day of opening of the tender. Now you are singing.
Where is affidavit in the 8 documents at 11?
Not affidavit.
8 documents which have been.
Yes, well, page 30.
Yes, page 30, not 25.
Yes.
Under clause 11.
Correct. Clause.
Speak about affidavit.
We have declared it, Milord. We have produced the affidavit.
Originally.
Original. At the time of opening.
No.
In.
No.
Milord,
That will be too far-fetched.
No.
As an officer of the court, you cannot make this.
No.
Affidavit, there is nothing called a photocopy of an affidavit.
No, my lord, I am not saying, my lord, I have made a categorical statement in terms of clause 11 of the special terms and conditions. What they have said is that you produce original documents at the time of opening of the tender, my lord.
What original documents? 8 numbers of original documents. You mentioned
Only,
it.
no, my lord, only,
Yes.
only the affidavit
Where?
of all those documents, my lord.
Where? Please read 11.
Well, just I come to this.
If you are
The
the-
firm suit, but I
Yes.
am right. The firm should submit the following document in original at the time of opening tender. So we produced,
What? Affidavit?
yes, before the
Where is the affidavit, requirement of affidavit here?
the requirement of affidavit is not there.
There is
my lord.
there is no concept of a photocopy of an affidavit.
No, my lord, we, according to the instructions, my instructions, my lord, my client have produced the original affidavit on the date of opening of the
That
bid
is not true.
documents.
If they would have considered, we don't have any objection, but we cannot force them to consider.
But
If they could have used the discretion, yes, of affidavit, a copy was given, now they have given same thing, only a original is given.
no,
But we cannot force them.
my lord, only thing that I can try to persuade my lord is,
You
can they,
have already tried.
no, my lord,
You have already tried.
one more, my lord.
No, you have tried your maximum. Hurts.
Because there is an arbitrariness in the action, my lord.
Hard. No, not required.
My lord, rightly he has started, my lord. My lord, tender authority, they are the best interpreter, my lord.
Here,
Yes,
interpretation is also not required.
does not error. My lord, para allegory is very clear, my lord. It doesn't
No,
talk
but
about it.
you could have used your sound discretion. Of course, that could have been a matter of challenge by somebody else. It's a different matter. But whether use of such discretion would be interfered by the court, that is also a matter of debate.
Man, everybody knows, but affidavit is to be furnished in original.
No, that is okay, but you could have exercised your discretion to accept it.
My lord, could have.
Maybe it's an inadvertent error. Next time, it not make this error.
Hope, my lord, both sides will, they will be vigilant in this point. Next time.
My lord will put the observation.
Heard Sri Titi Taralanet concept for the petitioner. Also heard Sri R.H. Nabam, the learned AAG, for the state respondents. Full stop. Do service report on the respondent, on the private respondents are still awaited, comma, in view of the order proposed to be such service may not be necessary, full stop para. In in pursuance, see, an NIT dated 27/7/2023 for so-and-so job, huh? The petitioner who has claimed to be eligible in all respects had participated in the said process. Full stop. However, comma, the petitioner would know, learned from a communication dated 27th July 2023 that it was not amongst, that the bid of the petitioner was not amongst those found to be technically responsible. Full stop. The petitioner accordingly sought clarification regarding the action of the authorities in holding the bid of the petitioner to be non-responsive, which was replied to by communication dated 28/8/2023. Full stop. By the allaying the apprehension of the ALLA1, allaying the apprehension of the petitioner that the rejection of the technical bid of the petitioner was not because of not submitting the documents in original as required under serial number, as required under clause number 11 of the special terms and conditions, comma, it has been stated that the affidavit which was required to be submitted was not done in its original form, but only photocopy of the affidavit was submitted along with the bid, full stop, para. 3, Tara, the learned counsel for the petitioner by referring to the aforesaid clause 11 has submitted that the original documents were to be submitted only at the time of opening of the tender. Full stop. Para. Countering the aforesaid argument, comma, the learned AAG has submitted that clause 11 makes it clear regarding the documents which are to be submitted in original at the time of opening of the tender. Full stop. He submits that 8 documents have been specified and those do not contain the affidavit which is required to be submitted. Full stop. It is further submitted that the original, that the 8 documents which, or 8 documents, comma, the original of which were to be submitted is with the objective to compare the same with the copies so as to come to a satisfaction of its authenticity. Full stop. However, comma, the status of an affidavit is different, and it is only the original affidavit which is required to be submitted along with the bid. Full stop. Tara. 3, Tara, the learned counsel for the petitioner has, however, submitted that the original affidavit was submitted at the time of opening of the tender. Full stop. Para. After considering the rival submissions, comma, this court is of the view that an affidavit is a stand-alone document and cannot be compared with the eight numbers of documents which finds place in clause 11. Full stop. This court is further of the opinion that even if the documents were not specified under such a clause, comma, an affidavit is always required to be submitted in original, as there is no concept of a photocopy of an affidavit. Full stop. The purpose of an affidavit to accompany a bid is to give a declaration that the papers, public documents submitted with the bid are true to the information of the bidder, and such requirement cannot be fulfilled by a photocopy of an affidavit which otherwise carries a legal sanctity. Full stop. Para. In view of the above, comma, this court does not find any inherent flaw in the decision-making process whereby the bid of the petitioner has been found to be technically non-responsive. In view of the above, comma, this court does not find, this court is of the opinion that no case for interference is made out, and accordingly, the petition is dismissed.
Yes. There have been a friction of mistakes. Then I could have pressed into Jagdish Mandal and further steal.
This is different. It's a greater, larger public.
Because that, Milord, I was aware.
You have to send Poder to Fernandez.
Yeah.
They'll have tea together.
I was aware, Milord.
Poder and JG Fernandez.
JJ Fernandez.
Well, this matter relates to,
19.
yes,
Your name
matter
is not
relates
there?
to land dispute, my lord.
Your name is not there?
Yes, in fact, my name is not reflected, in fact, but Wakalat
Doesn't
is there.
matter. Yes,
Yes,
what
my lord.
is this?
Yes, my lord. My lord, what happened in this matter, my lord, the lane was acquired for the national highway. Then the dispute started between the two clan.
Two?
Two clan.
Okay.
One is Nadong and another is Nebil. And then after the dispute, the deputy commissioner has constituted the board. Basically, it should be a village authority, but then board was constituted. And then board decide in favor of the respondent. And now
Somebody
respondent,
has passed away in the meantime.
yes, my lord.
You have implemented legal errors.
Yes, yes. We have implemented legal hairs. In fact, the petitioner expired, so we have implemented the legal hairs. So now after the passing of that order by the so-called the Kebang committee, in fact, it should have been the Kebang decision or it should have been village authority, but then it's they later they call it as a board.
Mr. Sekia for whom?
For the respondent number 5, 6, and 7, madam.
4, 5, 6, and 7?
Madam, may I submit that, madam?
4,
Please.
5, 6, and 7.
Madam?
Who are 5, 6, and 7?
5, in favor of us, my lord.
Who are you? Who are 5, 6, and 7?
That's the private respondent. Private respondent, my lord. Yes, my lord.
And Mr. Ram? 1, 2, 4. Yeah, 1, 2, 3, and 4. Land management is also there. Mr. Kamdukal is
Yes,
also
sir.
there. Okay.
And for respondent.
You have filed your affidavit with the respondents.
My lord, my submission is that, madam. My friend will agree to my submission, madam, proposition, madam.
How do you know he'll agree?
My lord, my lord, because he is agreed by the, my lord, decision of the Keva body, my lord, against which an appeal has been filed. Before the file before the deputy commissioner, my lord.
Okay.
But in a single line, my lord, the appeal was dismissed, my lord, without hearing that, my lord.
Oh, that is
My lord,
sad.
so my humble prayer is that, my lord, the matter may be remanded back to the deputy commissioner to hear the appeal afresh, my lord.
I think that will be better. We set aside the order of the deputy commissioner.
But we also pray for the satisfied of that
Keba.
Keba. In fact,
Keba decision will be examined by the appellate authority, the deputy commissioner. Under the administration rules, isn't it? 1940, what is
1945. Yeah, for Assam Frontier Regulation 1945.
Okay. Heard. The S now, Learned Council. For the petitioners. Also heard Sri Priram the Learned. Additions in here. Government advocate appearing for the respondent number 1. 1 only, no?
No, my lord, he will be appearing for 1 and 4.
1 and 4.
Yes, sir.
1 and 4. 3. D come to Learned Standing Council Land Management for respondent numbers 2 and 3.
Yes, sir.
And 3 are Sakya. Learned Council for the respondent numbers 5, 6, and 7. Okay. Mr. Mao, you're in a hurry while drafting the petition. See your response number 2.
Yes, my lord. Commissioner. Commissioner,
Department of Land Management. That's
Ye-
all. Nothing. You need to nothing.
yes, my lord.
Where? Department of Land Management, which government, which state?
Response number 2, my lord. Commissioner Secretary, Department of Land Management,
Thereafter?
Government of Arunachal Pradesh.
Where is that? Nothing is here.
I think in my petition it is there.
Your petition is not important for us.
Yes, my lord.
The petition chair file is important for us. Your petition, how is the response number 2 described?
It is correct in our populars. The Commissioner Secretary, Department of Land Management. Government
Maybe
of
some
Arunachal
mistakes
Pradesh.
are there, my lord.
In the copy which needs to be correct, you have not done it.
Yes, my lord, maybe it's
Don't
right.
know. Fair. Considering the subject matter of dispute and as agreed to by the learned counsel for the parties, the instant writ petition is taken up for disposal at the admission stage. Full stop. Para. The petitioners, who are 3 in numbers, are aggrieved by an order dated 5/10/2015. Now, we're aggrieved by. No, we're aggrieved by, where, huh? No. Order dated 5/10/2015 passed by a committee headed by the ex-Pro Assistant Commissioner as members of a Kebang. Full stop. The said order was put to challenge by way of an appeal before the appellate authority, namely the Deputy Commissioner Anjao, under the provisions of the Assam Frontier Regulation
45.
1945, isn't it? 45.
Yes.
Why are we writing 48 in your synopsis?
Okay, my full stop. 45. 45.
The petitioners are aggrieved by the mode and manner by which the appeal has been disposed of. Full stop. Apart from the fact that the appeal has been rejected, no reasons have been assigned for such rejection, and the
No
order-
hearing was done, my lord.
Order also does not contain any relevant discussion. Full stop. Para. The learned counsel appearing for the respondents have, however, submitted that though the rejection of the appeal does not appear to be erroneous, it is a fact that the impugned order passed by the appellate authority is not an elaborate one. Full stop. Para. Where is that order?
That, my lord, is in my lord.
Order by the appellate authority.
Appellate-
The order passed, order dated
26, my lord. 26, my lord. 26, type copy 27.
passed by the appellate authority on 2/11/15 has been reduced. Full stop. The Apart from the remark within inverted comma, already decision upheld, comma, there is no discussion of any nature. Full stop. The order also does not reflect that the aggrieved parties and the stakeholders were given a fair opportunity to place oblique defend their cases. Full stop. Para? A writ court in exercise of powers under Article 226 of the Constitution of India is to look into the decision-making process, and in the instant case, comma, the same process does not appear to have been done by considering the relevant factors and by making adequate discussions to the attending facts and circumstances. Full stop. Para. The order appears to be a cryptic one, which is not in accordance with law. Full stop. Para. In view of the above, comma, the instant writ petition is allowed by remanding the matter back to the appellate authority. Full stop. On receipt of the records, comma, the appellate authority is required to give don't say recorded. The concerned parties herein are directed to approach the learned Deputy Commissioner, Anja District, who is the appellate authority, on on or before today is 29th, on or before 12th of February, and furnish a certified copy of this order. Full stop. On receipt of the records and relevant documents, comma, the learned Deputy Commissioner, acting as the appellate authority, is to take charge of the matter and fix a definite date to enable the concerned parties to appear and place their respective cases. Full stop. The appeal may accordingly be disposed of expeditiously and preferably within a period of 2 months from the date of taking charge of the matter. We have asked you to go on or before a particular date so that you are aware of the case.
Yes.
Otherwise, even for notice, the case may again be delayed.
Yes, sir.
Once you are aware, he can give a date.
Obliged.
Yeah. 21.
Yes, my lord. My lord, petitioner, she has a land LPC, in fact, against which an LPC was issued in favor in the 2014. Thereafter, in the year it was issued in the year 2001 only. Thereafter, he has established his industry, her industry there, and still it is running. Now, what happened in the year 2014, my lord? The petitioner was in badly need of money. So, when the respondent, he came to know that I am in fact in need of money, so he voluntarily came and helped me out. In fact, my lord, I was having a loan of 60 lakhs, which I took from some people. So the respondent came to me and offered me to liquidate entire this loan amount, which I have taken from few people.
Okay.
So we have came into agreement that in lieu of that 60 lakhs, I'll be giving this LPC land to him. So on good faith, although it was not liquidated, so it was only agreement then. So on good faith, we have come into agreement. I have gifted that land to the respondent. I am fairly submitting that. But what happened after that agreement was executed, he fraudulently obtained LPC against that land which I have gifted to him. But he did not ever perform the promise that he will be this paying the loan amount which I have taken from people. So I lodged a complaint before the deputy commissioner repeatedly, and finally, deputy commissioner sir has marked my complaint to EAC Naharlagan. In fact, the subject matter comes under his jurisdiction.
Okay.
So my complaint was marked to EAC. Now EAC, what he in turn did, he referred the case before the Kaba.
Okay.
So there are three Kabas. In the first Kaba, I'll come date-wise. I am highlighting the fact now. There are three Kabas. In the first Kaba, he was upset. In the second Kaba that was held at Naharlagan, he came and he voluntarily stated before the Kaba members that yes, I could not perform my part of duty, so I'll not claim the land. Now the land belongs to the petitioner only. So that time in the second Kaba,
Has it been recorded? His statement has been recorded?
yes, Lord Sabha, I am coming to it. In the second Kaba, although both of us were present, but some vital witnesses were not there. So to do full justice, the Kaba members, they fixed another date, wherein it was directed to both of us to bring the witnesses. So on third occasion, I came with my witnesses, but the respondent remains absent. So since on the second occasion, he came voluntarily and expressed that, no, I will be not claiming that anymore, since I could not perform my part of duty. So basing on his statement in the second Kaba, Kaba has passed the decision. Okay, we have heard him in that particular day. He has abandoned his claim. So there is no point this keeping the matter pending. So Kaba took the decision, in fact, in his absence. But on the basis of the statement made in the second Kaba.
Thereafter?
Yes, thereafter, Kaba took decision, and that decision was forwarded to the deputy commissioner. Basing on that Kaba decision, the LPC issued to the private respondent was cancelled. Then, when this his LPC was cancelled, he again approached this honorable court by filing writ petition on the ground that while cancelling his LPC, he was not heard.
Okay.
Now, the court again directed the deputy commissioner
To reconsider.
to reconsider. Deputy commissioner fixed a date. Both of us participated. In the first day, we were asked to bring the documents in support of which we are making claims.
Okay.
So I brought entire document. He did not brought any document. I have brought entire document, but only the thing was that lordship, deputy commissioner, he refused to look at my document. Only what he was insisted was that since you have executed gift deed, and since it has not been revoked, I will not look at other documents.
get the give deed revoked first, then only I look entire thing. Then since it was not revoked, so therefore Deputy Commissioner passed this impugn order laws. Now I am before your laws. And
Who is our private respondent?
Respondent number 3 and 4.
Those
the
are
private
the-
respondent.
There are 2 persons. over.
Yes, Lordship. Lordship, this is not only the history, Lordship. During the pendency, Lordship, kindly appreciate, when the Deputy Commissioner cancelled his LPC, he filed writ petition as I have submitted earlier. That at that point of time, Lordship, he had already gifted the land further to this fourth respondent. He did not have any locus at that point of time when he did this approach this honorable court, because he has already gifted the land to the another person, the private respondent number 4. That fact was even suppressed before this honorable court. Now also, in fact, we have come to agreement that since Lordship, this court will be difficult to educate this matter, may I pray that Lordship, this matter may be remanded back to the Deputy Commissioner for fresh consideration. And while dealing with this matter, my document, whatever what the parties places, that may be.
But the observation of the Deputy Commissioner as the appellate authority, that unless the give deed is revoked,
Lordship.
you may not have a legally enforceable case. That observation does not appear to be incorrect or legally infirm. That's a correct observation.
Lordship, I have not gone into depth extent, Lordship. In fact, that give deed, Lordship, as for section 123 of this Transfer of Property Act,
Yes.
it has to be signed by 2 independent witnesses, and it has to be registered. And Lordship can see, I have annexed that give deed also. In that give deed, only one person had put his signature as a witness. So the mandate of this transfer of property says
But
that
that needs to be pronounced by a court of law.
that is true, Lordship. That is
Unless
true,
you put the give deed for revocation or challenge it, that it's not a properly constituted give deed. You on your own cannot say that no, it's not enforceable. You are signatory therein. It might suffer from some legal infirmity, but it has to come as a pronouncement by a court.
That is true, Lordship. That is not only the aspect, as I have submitted, Lordship.
No, Mr. Kamduk, what
No.
we are thinking a bit further.
Lordship.
You have said that the matter can be remanded back, but that may not be the end of the matter. Again, there will be a litigation. Remand here can say that, yes, I uphold my earlier views. You have to get your give deed revoked.
In that case, Lordship, I'll have to approach the civil court as your Lordship is indicating.
But was the give deed registered?
It was registered, but then Lordship, the mandate of this section 123 was not fulfilled, Lordship.
Registered give deed, you have to file a suit.
That is
for
true.
holding it to be inoperative in law.
That is true. At least, Lordship, at this stage, Lordship, our only agreement is that let the matter be remanded back to the Deputy Commissioner, because, Lordship, this is not the only issue. The issue is that, Lordship, another issue is that, as I have submitted, Lordship, when he had approached this honorable court by filing that writ petition, he had seized his right. He had no locus standi, because before filing that writ petition, he had already gifted the land to the other person.
Third party.
Third party, that is respondent
Now,
number
one
4.
counsel is representing both.
Yes.
How can we now say that he was not represented, or 3 is there, 4 is not there? Both are there.
No, Lordship, I'm trying to submit is that they have approached this honorable court. When his LPC was cancelled by the Deputy Commissioner, he had approached this honorable court saying that while cancelling his LPC, he was not hurt. So while filing that writ petition, he had already ceased to be owner of that land, because he has, before filing that writ petition, he has already gifted the land to.
No. That is what we're trying to say. There are 2 counsel, separate counsel for 3 and 4. Your present argument would have hold good Now there is one council, their interest is the same. Whether they have gifted or not, one person is one council is representing.
That is why, Lordship, let me place this argument before the Deputy Commissioner, Lordship, because whatever the Deputy Commissioner.
See, we can, on your agreement, we can pass that order, but that's not going to give you much of a relief. Unless you put to challenge that give him. I think simultaneously you should, I think, go ahead with challenging or instituting a civil suit.
Yes, Lordship, we'll do the necessary Lordship, this thing, Lordship, but since.
But to have an order of remand, we need to be satisfied that the order of the Deputy Commissioner is not tenable. He has given good reasons.
Lordship, may another.
You could have filed for a review. If review was rejected, you could have come here. Now you have come here and said that their decision is okay, there are other points. Now, unless we set aside the decision, we cannot remand it.
Even specifically, Lordship, I have pleaded in this writ petition that even that gift deed, which I have entered with the private listener number 3, it was not proper. In the sense that
that challenge has to be raised in the appropriate forum.
that is true, Lordship. But at this stage, Lordship, since I'm impugning the order passed by the Deputy Commissioner, Lordship, and there is materials which will support my case before the court of the Deputy Commissioner even.
No, if in the meantime, he had obtained a decree from the civil court holding the deed to be inoperative in law, then would have remanded the matter back, that you consider these aspects.
No.
Now, on what basis are we remanding? Only on your saying we cannot remand the matter. After he has discharged an official duty. Remand means what? We are finding fault with his action. What is the fault? Tell us. Prima facie, there is no fault. His observation has been rightly made, unless the duty is cancelled or declared inoperative. He is not in a position to do anything. Because dismissal of this writ petition will make your things worse. Other than the remand.
Then, Lordship, may I pray that this matter may be fixed some other time, Lordship.
Is there any provision for filing a review before the Deputy Commissioner?
In this
Check the rules.
in AFR, Lordship, I don't find there is no provision.
I think there is.
In AFR,
I think. If there's then we can say that there are other points also which the appellate authority could have taken into consideration. He wants to file a review, we can give a liberty to file a review. What is the effort?
AFR,
Just check. Now we have the course copy. Listen. Take it out. Have a look.
the Lordship, revision power is there. In fact,
Not
Lordship,
revision, review.
Review, Lordship. No, I don't find Lordship.
armed with a decree of the civil court, interfering with the gift deeds, or very difficult for us.
Yes, Lordship, prima facie, Lordship, although this, of course, is a issue which should be adjudicated by the civil court.
We'll take instructions.
Lordship.
We'll have it day after tomorrow.
Yes, yes, Lordship.
On the prayer of Sri D. come to learned concept for the petitioner. Placed on Wednesday, 31st.
Obliged.
Hearing matter.
Madam.
Yes.
My lord, this is the same case wherein your lordship has already passed an order in the principal seat. In similar case, my lord.
Principal seat?
Yes, my lord.
Which one?
Deserted, my lord. It is a case of desertion. Deserted.
Deserter case.
Departmental proceeding.
My lord.
Yes, Court of Inquiries.
You belong to the
ITBP Constable.
discipline force.
Yes.
Lordship, this is the same order wherein your lordship is.
We interfered or what? Interfered?
No, my lord. Prayer of the petitioner was rejected, my lord. Dismissed, my lord.
Rejected. Therefore, you are relying upon.
My lord.
What do you say, madam?
Your Lordship, I may give the facts and I have also some judgments, so I will like to place them.
Pronouns sumo.
Yes, Your Lordship.
How much time will you take, madam?
10 to 20 minutes.
Okay.
Yes.
And any other cases there? 34 is what, 34? 34, anybody is there? Would like to do the case today? 34, are you interested to do the case today?
Yes.
Are you interested to do the case today?
Yes, yes.
Today it may not be possible. We'll hear this matter.
Yes, yes.
He's going to file rejoinder.
Huh?
Just this morning, I have received this affidavit in opposition.
By the state?
Yes, by respondent number 3.
You are for the petitioner.
Yes, I'm for the petition.
You'd like to file a rejoinder?
Rejoinder.
Your name?
C. COVID.
C.
KOBIT.
COVID. You're with Mr. Yati? Or
Yes, yes,
okay. Or C. COVID. Learned Council representing the petitioners who submits that the affidavit in opposition.
My lord, the matter may be given a fixed date, since the leading counsel in this matter is delivered.
That's response number 4. What did you read? Affidavit opposition of the response number 4 has been filed today.
Respondent number 3, my lord.
3 has been filed today. And he will be allowed some time to obtain instructions / file rejoinder affidavit. Put some para. As agreed to, from our list on
28.
28
of February.
February 28 or 20.
28.
28/2. Put stop. Rejoinder affidavit may be filed before the said date, if so advised.
Much obliged.
Is there an interim protection? Is there any interim protection?
No, no, madam.
No interim orders. Yes.
Master. Your Lordship, the case, the petitioner was appointed in Constable in 25 October 2011
and he joined in
2011.
yes 2011, and he joined on 12 November 2011.
Yeah, appointed as constable.
Yes, Your Lordship.
Where?
ITBP 4th Battalion. He's Dirang. His past posting was in Dirang. So on 25/2/, 2012, his training started. And on the first day of the training, he got injured. After that, he couldn't recover properly. So on 25 to till 28th of the 2012, February 2012, he was injured, but he was not treated properly. But on 28th, he was taken to Bareilly for X-ray.
28/2.
Your Lordship,
You got injured on 25/2.
25, he got injured.
25/2.
Yes,
25 February.
yes, 25
And
February,
28th of February.
he was taken to hospital.
Which
for
hospital?
Bareilly District Hospital.
Where?
But it's in Bihar district.
Why,
Bareilly.
why not? You got injured where?
He was in training
Where?
in Bareilly.
In Bareilly itself?
Yes. Training center is there. So he was injured there. So he was taken there for medical treatment, and in X-ray it shows that he sustained fracture in his hand, but he was not treated. And he was just given some painkillers for long time. So he couldn't recover properly, and for treating for a long time on 25 till 9th of April 2012, he was in ITBP Hospital, Bareilly, Uttar Pradesh.
Where? Which period?
It's in para 5.
Which period?
From 25/02, it should be 28 to April, 9th April 2012. He was in Bareilly district.
28 to 12 to
Yes.
9/4/12.
Yes.
You were where?
ITBP Hospital, Bareilly. Earlier he was in district hospital. It is civil. Now he has taken to the ITBP Hospital, Bareilly, because he was not recovering. There also he was not treated properly, and he complained on 10th April 2012. He complained for the pain again. So at that time he was already back to the Dirang, and they have taken him to the Dirang Battalion Hospital, Unit Hospital. They have taken there, and doctor haven't done anything else, but they have given painkiller again. So later on 19th May 2012, the doctor of the Dirang Hospital, this unit hospital, they have consulted for to proceed to CRPF Guwahati for ortho consultation.
When?
On 19/05/2012. So when he went to the Guwahati, after looking at the injury of the petitioner, the doctor have granted him 42 days leave. It means he was injured a lot, but they haven't cared him properly. And after that break also, he haven't recovered well, but due to of his 42 days leave only, he have to return back, and he reported back on 17 July 2012 to the Dirang. And he was there for some time, and doctor also consulted him for like operation, but he couldn't do because he already back to the Dirang. Later, he again went to Guwahati Medical College, and he have done X-ray. It was same showing the fracture, but the department haven't cured him anymore.
When
So
was the X-ray done at Guwahati?
it was 19/7/2012. It is now long. Now his injury is worse. Then also the department was not providing him any leave. Then again, 9/8/2012, Guwahati Medical College prescribed him X-ray. He then X-ray again, and doctor said that he had to do operation because during that time he got some information from home that his mother is unwell and he have to leave for home. So he went to Dirang back, and he have taken leave, and he went to home back. Then at 21/09/2012, the petitioner applied for leave, and he went to his hometown, that is Coach Bihar. And when he reached home, he got to know that his mother is like mentally and physically not well. And after
When did you go to Coach Bihar?
he took leave from 21/09/2012, and when he went there and after on 09/11/2012, they found her mother dead because his mother was not mentally well, so she was roaming here and there. Then later, when she died, they found on 9/11/2012. On 23rd/11/2012, the petitioner informed to 4th Battalion through the facts that his mother is not no more, so he have to do all the rituals, so he have to take leave. So, but the authorities haven't accepted his leave applications. And when he reported back to the battalion on 7/12/2012, at that time he came to know that a few letters were sent from the battalion for show cause or like that, but he didn't receive that. When he went back there, he got to know that. Therefore, on 2012, he attended force court for summary disposal under Section 21B of ITBP Act 1992.
What did you do?
Sorry, Your Lordship.
2012, what did you do?
They have sent on 4/11/2012 and 29/11/2012, they have sent some show cause notice that he was staying on unauthorized leave. So when he went back to 2012, 12/12/2012, he went back to the.
You said 7/12 he had gone back.
It's in para 10, Your
You
Lordship.
said 7/12 he had gone back.
Yeah, he went back, but the court's summary court was happened on 12/12/2012.
Summary proceedings.
Yes, Your Lordship. Therefore, on 12/12/2012, he attended.
Yes.
Yes. He attended the force court for summary disposal under Section 21B of ITBP Act 1992. Accordingly, he was awarded punishment, 7 days extra guard, and 46 days was regularized because he was absent for 46 days because of the rituals. Even during that time also, he was not well, and his hand was not well because he was attending the rituals and he couldn't go for his medical treatment. Then on 20 December 2012, petitioner was referred by medical officer 4th BN ITBP Dirang to Composite Hospital, CRPF Guwahati, for his hand treatment. The petitioner kept under treatment. However, battalion hospital medical doctor didn't follow accordingly. They were careless about him. I don't know why. From 9/1/2013 to 25/01/2013, he had done X-ray twice. It was showing same result again and again, but they were careless about him. It was apparent from the report that his hand is fractured. Yes. So a doctor prescribed for operation, but he didn't have anyone with him. So he asked for some help from the battalion, so anyone can accompany with him, but no one was provided to look after him. So he's alone there. And during it, he wrote application on 10/06/2013 and 12/06/2013 for leave, but didn't grant it. He went back there after this condition had happened, and when he went back to Dirang on 10th and 12th June 2013, he wrote application for grant of leave, but they haven't granted him leave, so he have given wrote for leave for this without pay, but they haven't granted. So on 15 June 2013, he first he informed, but they haven't granted, but his hand was deteriorating day by day, so he left without informing, as per their allegation, without informing. On 18 June 2013, FIR was registered against the petitioner. On 15/07/2013, 2 West Bengal police personnel came to the residence of petitioner with FIR copy to know the exact condition of the petitioner, and they left when they witnessed his physical condition because he was in worse condition. So he was in bed and he couldn't get up even. So the authorities, the police persons came and took some documents, medical documents, and took one signature on one blank paper, and they went back. So he was in like comprehension that maybe they have submitted that documents to the 4th Battalion. And after that, again on 9th September 2013, Office of Commandant 4th Battalion have issued requests for apprehension letter to Superintendent of Police, District Coach Bihar, same police department. They have issued this apprehension letter, but at that time, nobody came from that police station. And on 26 February 2013 and 16 November 2013, the petitioner have submitted two leave applications or say requests for grant of leave to the petitioner.
What is your cause of action now?
Your Lordship, the termination letter which have issued, it was issued without conducting the code of inquiry. It was the violation of natural justice. The dissertation or in the dissertation also it's same. They haven't conducted code of inquiry and they haven't gave the show cause notice.
Termination order is of which date?
Termination date is of 15 April 2014. It's in page number 65.
You are not, no court of inquiry was held.
No, during termination it was held, but after when he received the termination, it was after 99 days, and till the time he was already terminated.
You were not given any opportunity to face any.
No. As per rules, I haven't got any opportunity. Even show cause was received after termination. For dissertation, they haven't served any show cause notice. They have provided that they have conducted code of inquiry, but I haven't received any code of inquiry or any show cause notice for dissertation.
Mr. Carter, what do you say?
Ample opportunity was given to the petitioner, and even my lord, the registered the case my lord, before the superintendent of the police to trace out this the petitioner. And after several efforts were made by the ITBP, normally in the ITBP organization, the employees are not being terminated. After several efforts were made, termination, infant termination order has been issued.
What does the record say?
Record says he deliberately deserted the ITBP, and on the
With the history which has been narrated regarding his injuries.
Injury can be treated at the composite hospital. We have in the ITBP and the army have their own hospital. It can be treated within the hospital, the department hospital. But instead of that, he taken treatment from the civil hospital, which is not permissible also. And after in the year 2014, and he was terminated. After lapse of 1 year, he started filing the representation, saying that no opportunity was given. And by now, it is already 12 years, almost.
When did you file this writ petition?
Writ petition have filed in 2012. Before that also he have filed, but there was
This one, this particular writ petition.
Did this writ petition filed in 2012? Yes.
Not 2012, 2022.
22, yes.
What were you doing from 14 to 22?
Your Lordship, due to lack of jurisdiction, he have filed first in Calcutta court. So there was lack of jurisdiction. So he came here twice. After that, from here also he have referred to the Central Administrative Tribunal, but it was not the jurisdiction. So he, after going to DIG, he came here last. The last impugned order is the of DIG.
When did you approach the Calcutta High Court?
It is in 2016, if I'm not wrong.
Today it may not be possible to continue, but continue tomorrow. Are you relying upon some case laws?
Yes, I have.
How many?
I have 3. Not very long, it's very short. If your lordship may permit, then I can.
No, today it may not be possible. Tomorrow we'll try. Okay. So this call. We'll try to finish up the matter tomorrow. Paucity of time did not allow the matter to be taken up today. As requested, list tomorrow for hearing.
Developed.